We ain't taking no days off. We put our lives on the line with this perpetual grind. All this hard work gon' pay off. Our main objective is to free minds. We don't like to waste time. We don't ever show off. We rather move in silence. My people about to take off, but we gotta be united. Self-realization was a must for me. I'm so in tune with myself, I never skip a beat. I meditate every day so I can keep my peace. But if you look into my soul, I promise you will see the creator chilling, sitting on his throne, yeah. Oh, you heard me right, my body is his home, yeah. Hey, I'm a God, can't nobody tell me different. Me and my father are one, y'all just don't get it. My consciousness has ascended to a higher plane, so don't expect for me and you to ever think the same. I help others find ways to cope with their pain. I do it all out of love, I ain't got shit to gain. See, my purpose on this earth is more important than me, and if I don't fulfill it, you gon' get this work from my seeds. I gotta keep going hard till I'm 6 feet deep. My presence still gon' be felt, you can't destroy anything.
They wanna hear from the mayor, if y'all ain't learned that yet. The mayor, not the trustees that don't do nothing, that only run their mouth. Y'all don't do no work.
Hide the money, y'all. There's poor people around. With your broke ass.
Every election. So now, because they can't beat me, they got to do this smear campaign to convince public opinion that I'm bad for them.
So you said 2 elections. You were first elected in 2021?
No, 2013 was my first election for trustee. I was a trustee. I sat where they are.
Right.
That's why I know the law.
Council.
Yes.
Elected mayor 2021.
Yes.
Terms 4 years?
Yes.
Okay. Plans of running for re-election?
I'm running for both my seats. And I'm going to win them.
So, and when is the election for Thornton Township?
2025.
So those elections at the same time?
They are.
Bullshit. A bullshit. A bullshit. A bullshit.
Okay, next.
I could not be here breathing and be comfortable if I was really as bad as they was making it. You know, nobody could be around me. So for me to be this calm, I must have some kind of inner peace. And my inner peace is knowing that once everybody take the time to really see what type of person I am, you'd be surprised that I stuck around this long.
I have to make the life that I do live as happy as I can and try to do the best with what I have. You know, live the best life I can live, be as happy as I can be. Nothing is perfect for anybody. I don't know.
Boys, I swear, I think I figured it out. You know why they don't want us redneck brothers and sisters and the hood brothers and sisters getting along? You know why? Because we'd be unstoppable. I'm telling you right now, we would shut shit down.
Yes. Blessings, blessings. Welcome to Uncensored Enlightenment Talk. And you're here with your host, Grace Levi. We here for round 3, baby. Look, I was about to put the 2 fingers up because y'all know I'm tired as hell. But God got us. I got my snacks. I got my food, my dinner, my drinks. If y'all haven't seen it, I hope you did see it. Thornton Township Electoral Board held their meeting today, or their hearing related to Tiffany Goons versus Napoleon. So what we're going to do is put Napoleon on the screen. Hold up. I want to say thank you to everybody who's in the chat. You know what we do. I'm going to let a lot of it play. You know, I'm not going to interrupt too much. I'll probably clarify some things if we have some audio issues. And then I'm going to let y'all do y'all thing in the chat. But you know what we do here. So thank you, y'all, for coming with round 3. Yes, I've been putting in the hard work. It was real today. So since I had time for it, So this is what we're going to put on the screen real quick. This is who we'll be highlighting today. Napoleon Harris, D-O-T-T. Hold up. And while we say D-O-T-T, let me put Fugly on the screen. Put them on a glass. All right. I still didn't merge the pictures yet, but I will merge the pictures. You already know what it is. And also, we're going to highlight our favorite guy, thicker than a snickle, Keith Price. Okay? So let's get this broadcast going because it's pretty long. Thank you for being here. Hit the like button. And the good thing is that we could fast forward. baby, you want to return? We can fast forward, please, because it was kind of long. All right, so let me take myself off the screen and get this together. And also, before we start, I want to say shout out to Burgundy Blue. I already put it on the screen. We are using her live. She put in the work. I'm trying to tell you, it ain't easy. She was already like, so I need to get my snack. She was like, y'all don't want me to be passing out. I'm telling you, the sugar be going low and everything. I understand. So shout out to her being out there, allow me to use her clips, keeping everything neutral. As you know, we all are different, but I definitely appreciate her, letting us use it because we do it. We do this. And she haven't gave us any issues, So despite what y'all see and everybody got their own little thing, at least we keeping things mutual for the residents. You see what I'm saying? Okay. And Alexis Wilson. Say her name, baby. And I could play a little faster, y'all. We got the benefit.
Okay, I've got a motion made by Member Swanson and a second by Chair Raymond.
Let
All
me
in
see.
favor? Okay, motion carries. So we will now call case number 25 TOEB Suit 02C. Attorney Krafthofer?
Is it too fast? Let me know.
I can't hear you in verbal numbers. Okay. Okay, we can hear you. This is going to be an interesting hearing, just because of the technical difficulties that we're having. So I just ask everyone to bear with us. Okay, so there was a motion to strike and dismiss filed in this case. And so I think that the first thing for the board to do would be appropriate to hear the arguments related to the motion to strike and dismiss. Does the board want to put any restrictions on the arguments, or how much time do the candidates think that they're going to need for each side of their argument? Or the parties? I'm sorry, I didn't mean to say the candidates, the parties.
I don't think we would need more than 15 minutes.
Okay.
15 minutes?
I just want to say, we have thoroughly read, and I'm speaking for myself, if the board can tell me if they agree, the objections, and we had quite a bit of time to thoroughly read the motion to dismiss, unlike some of the pleadings that I received this morning. And both were very thorough and well written. So if it's possible to just not read what you already wrote and just hit on the highlights, and to keep it to 10 minutes and then let us ask questions of what we are wondering about after reading it, that would be very helpful.
I have no problem. I was not planning to read word for word from my submission.
And Member Ostfeld, are you good with the 10-minute limit for oral argument for both sides?
I'm fine with that. I just like to have the record and outline of the points that the people raise, so that they don't read everything, but they do state for the record what the basic points are that there are.
Okay, so you're asking them to just give a sort of summary.
A summary overview.
Sure. I think that they both probably intended on doing that.
I could do that relatively quickly.
Okay, Mr. Mullen, you're good with this as well? Okay, Ms. Krafthofer? Ms. Krafthofer, you're good with that as well? You just give me a thumbs up if you want. You're muted.
Yes, that's fine.
Yeah, we're having a lot of trouble understanding through this feed. Possibly. Okay, well, we'll figure, I guess let me ask this. Will Mr. Mullen, are you going to be handling the argument primarily?
I will handle the argument primarily, yes.
Okay. And then,
Are you able to text you or?
We'll try to do my best.
Thank you.
okay, and then for the board members, Ms. Krafthofer has put on the screen that she's only able to hear me. So I think it's possibly your microphones might be off. So if you are going to speak, just so that Ms. Krafthofer can hear what's going on as well, just turn your microphone off and then you can, or on, and then you can turn it off to avoid feedback issues. So thank you, everybody. All right, so then I guess we should get started. Mr. Residency, is your motion?
I will start off. The first point is that the objectors filed a verified petition. And their verification does not say anywhere upon information believed. It says we have personal knowledge of all these facts and these allegations. In the response, the true nature of this objection comes out. And it's a quote. This is the worst kept secret in Thornton Township. If we want to go by gossip and innuendo, we will be here literally for days and weeks. If they had personal knowledge and facts, those should have been pled. This is no different than when someone files a mortgage foreclosure or some other verified pleading seeking this type of relief to remove a candidate. But they chose not to. And the reason why they chose not to is because they don't have a case. And this even becomes clearer. Point 2. They changed their objection. The objection now is my client never lived at the Harvey residence. That's not pled anywhere. How is my client supposed to mount a defense if the objectors are going to make these shifting arguments? I cite the Maskin case, and they want to talk, it's all about proof. They're wrong. Maskin talks about what must be proved, but what must be pled. They have never pled in this case that this is an abandonment case. So what documents do I have to gather for this case? They don't. They don't point out that, are they saying that this 30-day rule about residency under the township, you have to live in the precinct and be registered and live there for 30 days before, are they going to be counting the time that my client was in Springfield? Is down. They've not provided any information. I cited the Daniel case, and the reason why I cited Daniel versus Bailey, and they want to talk about, well, that was kind of a shotgun objection because it dealt with signatures. This is no different than a shotgun objection. You're not a resident. We're gonna shift the burden to you, Mr. Senator Harris, to show that you're actually a resident. The burden's on you. We've provided you with enough information. One of the best known facts is Senator Harris owns a Beggar's Pizza and several other Beggar's Pizza. One of them is in Harvey. His Harvey residence is right by his restaurant. There's an article, we provided an article where he's actually worked in the restaurant. So, okay, yeah, that's where he works, and he has a residence there nearby. What do they cite? They cite, we have personal knowledge. My third point.
All right, wait, I just want to keep y'all up to date that I haven't watched this as well, Honeymoon. So this is, and everybody else is going to be new to me. So there is some things when it comes to addresses and primary address that I know about. So whatever I hear that I feel is important, that's what we're going to be addressing, okay? So this is kind of new to me. Shout out to everybody who watched it before and that's watching it now with us. All right, get in the comments. Tell us how you feel.
Before we go any further, and under this board's rules, if these 3 objectors have all this personal knowledge, because it is the worst kept secret in Thornton Township, they need to testify as to what their personal knowledge is. You don't get to have to sign a verified complaint and then say, well, no, that's not fair. We don't have to do anything. Well, yeah, you do. Under the rules of this board, under the Daniel decision, they have to. That becomes very, very, very important. My last point, and this goes to why this should be dismissed. You've already had a taste of 2 of the objectors with regard to the one objection as to whether or not there's a full objection filed to Mr. Harris. I also cite the Muldrow decision, where that electoral board sat at the city of Markham City Hall at 1:15 in the morning, in which Mr. Price instructed a witness to leave. What this is going to turn into a game. And when someone alleges that someone doesn't live there, okay, simple checking of public records that we provided you all the petition sheets, provided, in response to their subpoena, like, listen, they're asking for mortgages. There's no mortgage on this Flossmoor property that Senator Harris happens to own. There's no homestead exemptions on there. What they're going to say is, well, you need to put that on in your case. No, they have the burden. They have not pled sufficiently a residency case, because the purpose of this, to fully state your objection, is to allow the candidate an opportunity to, what do I bring in and defend? Based on their response, they want Senator Harris to bring in literally 15 years of documents to establish his residency. That is not what the law is. They have a deficiency in their pleading, and for those reasons, this objection should be dismissed.
Thank you. Mr. Mullen, would you like to respond?
Absolutely, thank you. We're at the pleading stage. This is a standard residency objection with standard residency objection allegations. These are similar to the residency challenge that have been filed by both counsel on the other side. I've been doing this for a long time. I have never seen in a case an allegation that there was not physical presence or there was not an intent to remain, that it was abandonment. The allegation is simply there is a 1-year residency requirement and a 30-day requirement in the precinct to be a registered voter, and that was not satisfied because the candidate said that he lived in Harvey, which is in Thornton Township, when in fact he lives in Flossmoor, which is in Rich Township. And that is the allegation, and we are required at the evidentiary hearing to bring forth evidence to prove that. But this is the pleading stage, and we have gone beyond what is required at the pleading stage by including exhibits in our petition, and those exhibits included the homeowner tax bill showing that Mr. Harris owns the property in Flossmoor. He filed with the State Board of Elections paperwork over many, many years saying that his residence is in Flossmoor. And the form that he signed to say where his residence was under oath. So we have provided a great deal of information to back up and show the good faith of the allegations that Mr. Harris is not a resident of Harvey or Thornton Township. That is not required. What is required is an allegation to state what our objection is. And our objection is simply, he is not a resident of Thornton Township and does not meet the residency requirement in the township code. And second, that he is not a registered voter because he has not lived in the precinct for 30 days. And therefore, he is not qualified under the township code. And when he signed his statement of candidacy saying that he was a resident in Harvey in Thornton Township, he was not being truthful. And therefore, the statement of candidacy includes a falsity and is invalid. That is the allegation, and we have to prove that allegation. We understand that. But no matter how much documentation Mr. Residency comes in with to try to get rid of this case at the pleading stage, this is just the pleading stage, and we have alleged everything we are required to allege. There are a lot of cases that have been cited here, but what you don't see is a single case dismissing a residency objection on the grounds that physical presence, intent to remain, or abandonment has not been pled. Not one. In all of that. With respect to the objectors, there are two cases that are relevant to the objector's role in this process. One of those is the Daniel case, which Ms. Residency litigated and cited. The other is the Nader case. The Nader case dealt with a request for a subpoena on the objectors. And what the Nader case says was that is outside the scope of the board's duty, that you are not to look at what the objectors did, what the objectors did together. The only question before the board is the candidate a resident of Thornton Township or not? Now, if Mr. Residency believes that the candidates have personal knowledge and they did verify and that is correct, then he can call them as witnesses and ask them what their personal knowledge is in the evidentiary hearing. But he cannot subpoena them under the Nader case to ask them how they put the objection together. Now, when you look at the shotgun cases, what they do is they look at the documentation that was filed. And they say, this is shotgun because every signature was objected to. And you look at the documentation, and from its face, you see that it's a shotgun objection. You don't have someone come in and do testimony on whether or not it's a shotgun objection. You look at the paperwork and you say, does this appear to be a shotgun objection? If you're sure it is, then you get rid of it. If you're not sure it is, then you do a 10% record check and see whether it's good or not, right? You don't call in people to testify, well, I went down to the board and I looked at these signatures. That's not how the process works, and that's what the Nader case says. So we're happy to have our clients testify as to what they know, because they know a lot, and they did a lot of work on it. But it's not a question of whether the petition has been pled properly. It's a question of our burden of production and our burden of proof at the evidentiary hearing. So for purposes of pleading, this is an allegation that has been adequately pled and adequately supported to show that it's in good faith. The motion to dismiss should be denied.
All right, do y'all know what's going on? All right, so both of the lawyers spoke. So this is the breakdown because y'all said I had a serious face on. I had to be right in. All right, so basically Napoleon lawyer saying that it's pretty outrageous and it's too much for them to be asking for 15 years of proof of residency, for one. So that is the argument. And then they want to call out, I would assume, Keith Price and Smith, based on them making a statement saying that they have personal knowledge. So then you move on into the objectives. That lawyer is basically saying that is not typical practice for basically Napoleon lawyers in their position to call on the opposition to testify. So that's why they stated the Nader case. That Nader case highlighted that you can't call on the objectors as witnesses. But we did see Smith go up as a witness. You remember when Wells was looking at him all crazy, and then he went to testify over the other papers, and that had to do with the supervisor position excluded him, the other live. Okay. Now, so that's a little bit weird. Just keeping that in mind. Like, okay, but this is his argument. You ain't had no problem with, well, actually, it was, I don't think he was there. It was Smith and KP that was representing themselves. So this lawyer is basically bringing up case law saying you can't put me on the stand. You can't put my, objector on the stand. Now, what else did they say? The issue is that they're trying to allege that Napoleon don't live in Falsmore. And from what I'm hearing is that is part of his original filing. And I think, what he's always filed, I don't know how far dated back in his politician career, but it seems pretty far back. So I'm not 100% sure, because we're going to get to that, what evidence that Napoleon lawyer have, but it is the duty of the objectors to bring evidence forward. And the objectors in this case is them, and then it's these lawyers, and then it's Catch a Dog Smith, and So this is what's going on. Now, let me see if there's one more thing. Oh, this situation, he's saying, is putting Napoleon in a compromising position, basically saying he filed his papers fraudulently. So he was like, this is the reason why he wants the people who say they have direct knowledge to come, because if they testify, even though this is not like criminal court and civil court, this election board hearing, you know what that is. They're going to be lying under oath. And that's what they're trying to set up. That's what the other lawyers seem he's trying to set up. So let's get back to it. That was just a little quick breakdown. Hit the like button. Let's go.
In reply, Nader is a different case. Nader was not a verified petition. Your rules address this issue. I've handled plenty of cases where there's allegations of shotgun objection and people have testified. Senator Ricky Hendon had to testify at a hearing as to whether or not the petitions were the objections put together. This is not a case where I want to know the motivation. Is we have people that have signed a verification. This is true and correct. And so they attach a document. This is an article from the Lansing newspaper. Okay, something off the internet, that's great. I can find that. But it becomes true when you look at the response. The response says this is the worst kept secret. So this is gossip and innuendo. This is no different than the Burford theory involving President Obama. And courts ruled, you want to make this objection, he has to come forward with this person. This is just nonsense. What do you have? What evidence? If you're going to make this allegation and verified petition, what do you have at the time you signed that verification? Not what you did afterwards, what you did now. They cite to the State Board of Elections website page they did it. That's his mailing address. That's a mailing address, not his residence address. We are going to be faced here, and this is the burden that they have. They have to plead and prove. What are they pleading and proving? What are they pleading? What do I have to defend on behalf of the candidate? Because if you look at their response, they say he never lived there. So I have to go back and get 14 years of records. They're trying to amend their objection. They want this to be very fluid, and I'll call it loosey-goosey. You must fully state your objection for the purposes of the candidate's due process rights and what I have to bring in to rebut. As I sit here today, I do not know what they're really alleging because they did not sufficiently allege the following, okay? Like in Mascom was a detailed petition that had detailed facts of points in time, events. There was actually a resident that moved into that residence that was cited. The lease was cited. The voter registration of that new resident was cited. There's nothing here other than, like I said, gossip and innuendo. These cases cannot be brought this way. This board should not be forced to sit here for hours and hours and hours for someone to engage in malicious mischief. That's what I'm calling it. If you had all this facts, all these personal knowledge, he doesn't live there for the following reasons, that should be in the objector's petition, the verified petition, because that would be the basis for their objection, setting forth what I need to defend.
Okay, so our vote party's done?
Yes.
Okay, thank you. So now it's time for the board to begin its deliberations. So I would ask the board to, I guess, just start discussing this and give your thoughts. We'll take member Swanson. We'll take, you got some thoughts you wanna?
Mr. Residency, as to your question, they even have to go back 14 or however many years. The law only says residency for a year and to be a voter 30 days in the precinct. Why do you have to go back 14 years? No relevant time period is just the 1 year.
Their response says he's never lived there. So their response is going to be, he never lived there. So I'm going to have to go back in time and start when he started his physical presence there.
But all is relevant is 1 year.
But it's clear what they plan to do because they're saying he never lived there. So now how do I, because they're going to point to, oh, he lives in Flossmoor. Okay. He lives in Flossmoor. I have to go out and get witnesses now from Flossmoor that no, he has not been there for X years. That is what my concern here is. If when you read their pleading, and I understand when they have to plead for 1 year, but that's not what they're doing with their response to the motion.
Do any of the board members have any questions of the candidates council or objectors council? Sure. Yeah, that's generally appropriate. I mean, sometimes with these electoral board hearings, we don't always follow Robert's rules to the letter just because they're a little bit more informal, but.
I like that idea.
Yeah, I'll put a motion on the record that the motion to strike and dismiss page 25 TOEB sub 2C be denied.
Second.
Okay, so we have a motion by member Swanson to deny the motion to strike and dismiss, and we have a second by Chair Raymond. I will call the roll. Well, I'm sorry, first you guys want to have discussion. You said you want to have discussion. Let's have a discussion.
I would just like to point out a couple of things. One, I agree with my fellow electoral board member and the attorney Mullen for the objector that the candidate's attorney maybe is going on a little bit of a stretch when he says he has to prove more than the 1 year prior to 30 days, just because of some wording in his reply or response. So I don't agree with that. I guess if your candidate lived there this year, show us that he did. I definitely don't agree that it's a shotgun allegation.
If I may interject, the burden's not us to show that he lives there. The burden's on them.
Okay.
They're shifting the burden. See, this is what my concern is. They're shifting the burden to us.
It does end up usually like the Ronald Mandel case. They proved the wedding gown was there. Show me a wedding gown. Anyway, I don't agree at all that it's a shotgun objection. To me, it's the complete opposite. This is one narrow area of law, whether he's a resident or not. It is not challenging 5,000 out of 5,001 signatures. So I don't agree with that argument. You cite the case of Jeffers, which refers to one meager sentence. I don't agree that this objection raised one meager sentence. I may agree with you in a different case before us, but I don't in this one. I think they added details that made me curious, like the vacant issue of the water bill. I think they gave details more than just a mere allegation of residency. So those were just a couple of points I wanted to bring up.
Okay, thank you. One thing I did want to actually point out to the board, because there's a lot of talk about this 30-day thing as it relates to section 5/5-2. I just want to make sure the board is aware of what that section actually deals with. That section deals with registering to vote. That section states, and I'm going to read it into the record for everyone's benefit. No person shall be entitled to be registered in and from any precinct unless such person shall, by the date of the election next following, have resided in the state within the precinct 30 days and be otherwise qualified to vote at the election, at such election. Every applicant who shall be 18 years of age or over on the day of the next election shall be permitted to register if otherwise qualified to constitute residents under this Article 5, Article 3 is control. So I just wanted to make sure that the board is aware that that section, it's not per se a residency section, and it doesn't per se require somebody to, I guess, be a resident 30 days prior to the election. It actually is a section that deals with being a resident 30 days prior to registering to vote. So I just want to make sure the board is aware of what that section says. At least that's my reading.
See, that was, yeah, it was just gross for them to ask for 15 years. But we're gonna, people who watch this, I want to find out what happened with the subpoena, because they've been trying to subpoena this information, because that's the only way they're really going to prove it, or to do their research and find some proof.
Thank you.
Okay, Member Asfeld, is there anything that you wanted to add?
Basically, I think this is a factual situation, and then I would go along with the motion to deny the motion. I would go along with the motion to deny the motion to strike and dismiss, because I think it's a factual issue, and it only goes to meeting requirements to be a candidate. It doesn't go to anything else. We don't want to hear 30 different witnesses, and you know, it's hard to prove a negative. I understand that, but this has to be a fast track. It's not your normal procedure, and so we just need to move to basic evidence.
I believe that Member Swanson wants to offer some more statements.
Well, I agree to some extent with Mr. Residency that the objection could have been worded with more specificity. However, this is the pleading stage. I believe there is enough there to withstand the motion to strike and dismiss. Whether there's enough there to be brought in and prove it at trial is another issue, but that's not what is before us at this time.
Okay, so then at this time, is the board done with its deliberations as it relates to the motion to strike and dismiss? Okay, so then we'll go ahead and call the roll. So just for the edification of the public, we are now voting on the motion, which was made by Member Swanson and seconded by Chair Raymond, to deny the motion to strike and dismiss filed by the candidate, Napoleon Harris. I will now take the roll. Chair Raymond?
Yes.
Member Swanson?
Yes.
Member Asfeld?
Yes.
Okay, so the motion to strike and dismiss has been denied. The next order of business is to move over to the subpoenas. And the subpoena request, as the burden on this case is on the objector, not the candidate, it would be my suggestion to discuss the subpoenas presented by objectors first, and then move over to the subpoenas requested by the candidates. Do the parties agree with that order of presentation?
That's fine.
And could I ask of the objector if there's any way to limit the subpoenas? Could you tell us that now?
Well, I think that first we should hear from both parties as to what their arguments are really quickly, and then I think that the board should discuss what limitations, if the parties are willing to self-limit, then that's great. If they're not, then obviously the board needs to make a decision as to what sort of limitations it wants to put on the subpoenas.
After an initial presentation from the parties, I envision after looking at the subpoenas and requests, we're going to have to deal with them individually one by one.
I believe so. Okay, so Mr. Mullen, do you want to go over your request for subpoenas?
Thank you. As we just discussed, the question next Friday is going to be whether or not there is sufficient evidence to show that the candidate does not live at his residence. And so, in addition to the documents that are publicly available, and we have issued FOIAs, we have done public record searches and things of that nature, there are individuals who are unwilling to give us information, whether that be testimony or documents, and we, as a result, sought to compel those by subpoena. And so there are basically three categories of subpoenas that we ask for. The first is the candidate and his wife. And this asks for them to both appear and testify at the hearing as to the facts regarding their residence. And second, to provide materials that would presume to have their address on it. So their bank statement, their cell phone bill, their water bill, their gas bill, things like that. And those are pretty standard requests of a candidate and the candidate's wife. In fact, I used Mr. Ladizinski's subpoena on my candidate in a case a couple weeks ago as the model for what I used to draft the rider for the candidate here. And so we're not asking here for personal information. Like, we're not asking who the beneficiary is of their life insurance. We're not, and we put on all of the subpoenas a redaction notice saying, redact the confidential personal information. All we want is the information relating to the address of the candidate, in some instances, the candidate's wife or the candidate's family. And these are fairly standard requests with respect to the candidate for documents in their possession that indicate where they and their family live. The second set of requests are subpoenas with outriders, and those are subpoenas on a number of individuals who reside in Harvey, nearby the address the candidate says he lives, and a number of individuals who reside in Flossmoor, near the address that we allege the candidate lives at. One of the individuals we've asked for is actually in a townhouse adjoining the building that is listed as the candidate's address in Harvey. And while these individuals may be willing to talk, there are a lot of reasons why they're not willing to talk or they're not willing to appear. But these are the people who will have personal knowledge of where Mr. Harris spends his time, because they're the people in closest proximity to the two addresses that are alleged to be his residence by the candidate and alleged to be his residence by the objector. The third group of requests are subpoenas due Stacom to entities. So the Village of Flossmoor, the Park District, the Library Board, the Illinois Secretary of State. And these are for what the candidate uses as his address on his official documents. And it is entirely common to get the address of the Secretary of State, what the driver's license is, where the vehicles are registered, and things of that nature. That is a extremely common subpoena. Mr. Steckler filed in another case in December and received all that information from the Secretary of State. So again, finding out what address the candidate uses on official documentation is relevant. And those are essentially the three buckets. With respect to some of the objections, we understand that this is a lot of subpoenas, but that doesn't put a burden on anyone except for us, right? We have to serve them. We have to get the documents. It doesn't matter to the Village of Flossmoor whether we've also sent a subpoena to the Park District. It doesn't matter to the Park District whether we've also sent a subpoena to the library, right? They only have to answer their own subpoena. So we also know that we are back here in 5 days, and we're not going to be able to serve all of these. We're not going to be able to get a response to all of these. So while it may seem like a lot, what we're doing is making sure that we're going to get enough to prove our case from what we send out. And again, these subpoenas are seeking address information. They're not seeking financial information. They're not seeking personal information, etc. And the only other thing I would say about the subpoenas is, this candidate has been accused in multiple occasions publicly of not living where he says he lives. And this has been something that's been going on for a long time. So we expect that the candidate has done work to cover his tracks, and that it may be more challenging to prove that he doesn't live where he says he lives. And so we believe that we've got to cast a wide net. But none of this is unusual. None of this is unreasonable. These are standard subpoenas. I've been a litigator for almost 30 years. I've sent out hundreds and hundreds and hundreds of subpoenas, and I've always been able to work out with a person's subpoena how to respond to them, right? We've never had motions to quash or motions to compel, because you work it out. You know what you want, and you can work it out with the person that's being subpoenaed. And I don't think there's anything oppressive about any of the individual subpoenas that ask the library district, what address did the candidate and his family use to get their library cards? That's not an oppressive request. To ask the park district, do they have a park card? To ask the village, do they have a car sticker? And what address did they use to get their car sticker? Those are simple subpoenas for basic information about where the candidate lives. And so we think, as a general matter, they should be granted. If there are concerns about individual ones being overbroad, or individual ones having other issues, we're more than happy to make this reasonable for everyone involved. We've got 7 days to do this. We're not, we're not trying to break everyone's back. trying to get as much as we can in a short period of time. So we ask that those subpoenas be granted.
Thank you. I did have a really quick question, Mr. Mullen, just something.
Okay, before she go, can I just do a little brief recap? This was like, whoa. So I'm going to be honest. The things that the objector's lawyer is looking for is not too out of pocket. What he's trying to do is cross-reference Napoleon address across 3 different ways. So one of the first ways is that they allegedly freedom of information request the information to people who was affiliated or maybe owned, like just say one of the apartment he lived in. They was talking about that in Fossamore versus Harvey. Now it is a part of Fossamore. I think it's a little part of Fossamore from my knowledge that I was told by, I think, educated when I was down there, is in Thornton, but maybe where Napoleon is at, no. But the first thing that was like, bow, they want to subpoena his wife and him to come and testify. So that right there is putting them in a compromising position if they're not telling the truth. And I know this is the election board, but at the end of the day, it's still his testimony. Can't lie under oath. So then, okay, so they having problems with those people who really don't want to testify. So that may not be an option. But they want to cross-reference with basically personal information. And that's what I was telling people. When you have different properties, different places, your main property is the one that they're going to base where they serve you at. And if y'all don't understand, let me give you an example. Y'all may not know nothing about this, but Jay-Z allegedly got a lost son. And that lost son has been one of the issues that it was hidden for so many years, is that when he was servicing, allegedly, he wasn't able to service the right place. Now y'all can do y'all research on that, and what ended up happening is that they was taking them ring around the rosy. So what the objector lawyer is trying to do is saying, hey, we could use your driver's license, we could do state filings for your businesses and the entities. Also we can do that address, light bills, or you're gonna see later on, because I did see a little part where they was talking about involving subpoena in the kids' school, which was a lot, but they want to use that to cross-reference. And what that goes to say, that could be foundations for fraud, which is a whole nother aspect. And that's what the lawyer was talking about. Like, we're not trying to open a can of worms here, but this is what is standard, and this is what we usually ask for. So that's why I was like, ooh. So now let's see what the lawyer has to say. Thank you for being here with Grace Levi. Please hit the like button. Y'all are doing amazing in the chat. Shout out to all our mods. Got Honeymoon in there. And I do apologize. I didn't mean to put you on timeout, sir. I was just hitting a button. I was doing a lot being my own producer. H-Spad, shout out to you. Sharp, shout out to you. And Norm, shout out to you. So let's keep it going. I just wanted to do that little intermission.
Excited related to the subpoenas to the various public entities. I was just curious. I know you guys said you filed some FOIAs and stuff like that. Did you happen to FOIA those public entities yet? The library, the park district, or anything to get any of that information? So what was the result of those FOIAs?
Right. So as we put in the motion, one thing that they can delete the address from the FOIA response. So we can't get. So there's some things we can get from the FOIA, but that from the city for whether he has a parking sticker, they're going to redact.
Right. But they would still have some sort of record that at least that responsive record might exist. So again, I'm just wondering.
I know that we have filed FOIAs. That's a question, honestly, for Ms. Krafteffer, because her firm has been doing the FOIAs. I have not. So if you want to ask her, but I do know that a number of them have been done, and we're not trying to be duplicative of things that have already been requested.
Okay, I was just trying to see if there was a way to narrow the scope. Does the board want me to ask Ms. Krafteffer? All right. Hopefully we can hear you well. So the question was basically that, what sort of FOIAs, who did you guys FOIA so far? I guess the public entities, and what have you received?
So we have some entities have provided, but we have not yet
Carolyn, the connection is poor. Let me ask you, is there a way to turn it up without causing a bunch of feedback?
Everybody in my room, mute your microphones.
Yeah, let's try it. We're going to all mute our microphones and we'll see if that works. Give me 1 second.
So I'll give you one example. So, actually, I turn this off. So we did FOIA for his paycheck information from his job as state senator, and so we have the stuff that is addressed to Baltimore from the state of Illinois. So that's an example, and we're not trying to get things that we can't get, but the stuff that we are asking for, I don't believe we can get elsewhere.
Okay, I was more trying to figure out sort of what has been filed so far and what is still pending.
And I can add to that, I filed some FOIA requests and I worked with Terry and for example, the village of Baltimore State Board of Elections, but also like that in drafting other FOIA requests, just generally responding to them. You, as previously been said by Mr. Mullen, is if you go searching for documents from a certain address, the address can be redacted. So
absolutely,
will be useless. And if we do say the names of one information just on this name at this address, the information we could get could be so worthless that we wouldn't actually be going on a fishing expedition. We want to avoid that. We want to give you proper documents with proper names and proper address.
Okay, understood. I just was trying to clarify what has been done so far. Okay, I have no further questions of Mr. Mullen, and I think Mr. Residency was going to reply. I did want to read really quickly into the record the comment that Ms. Craftover had said. She said, we have requested information from some entities and the subpoenas do not include the entities that have responded with the addresses. Otherwise, it is an exemption under FOIA. The public bodies do not have to provide residential addresses. So, okay, so we're ready for you, Mr. Residency.
Justin, okay. We have spent a lot of time going through each one of these subpoena writers in these subpoenas. My concern is one of what Mr. Mullen said. We send a subpoena out and someone sends them all the bank information. Oh, I'm a lawyer, don't worry about it. I'll protect your private information. I know how banks, I got a subpoena, we're gonna produce records. It doesn't just limit to the information about address. Sending a subpoena to the Illinois Department of Revenue for someone's tax filings, okay, what does that have to do with residency? Okay, you want the address? These subpoenas are overbroad. It's not your duty as a board to redraft these. Let's talk about the subpoena requests to my client and his wife. Communications regarding children in their schools, any mortgages you have. My client owns several businesses. What do those have to do with this? Do they limit that subpoena to either Flossmoor or Harvey? No, they do not. We've identified all these issues like insurance policies, medical insurance, life insurance. Really? This is, and I can hear Mr. Price, they're going there. Yeah, this is a game because guess what? There's no protective order here. And when this stuff gets out there in the public, and believe it or not, there are actually election lawyers that have filed people's social security numbers and dates of birth in public records. And if I was a voter in Cook County, that's what I really feel proud that I know that lawyers are going to get this because once this records exist, this record gets filed at the Circuit Court of Cook County. And we can talk about redactions, all right? Oh yeah, these documents are going to come to counsel in the form a financial institution produces it to them, all right? And I'm not saying Mr. Mullen's not going to redact it, but now I have a lawyer, an opponent, and let's be clear here, they represent an opponent in this race, Chris Clark, all right? There's no protective order in place here, other than Scout's honor. As a lawyer, I'm not going to do it. So when you look at, and let's start with my client and his wife, and look at how there's no restrictions on some of these documents limited to the two addresses. There are none. Especially with the issue of the mortgages and other documents. I've already talked to you about IRS, ID, the Illinois Department of Revenue. My client's going to give you, he's going to, don't get his driver's license, so I'm not going to be happy with the address.
Madam Chair, I would suggest that the objector subpoena the candidate to produce a limited number of documents, and the candidate can redact what is not essential to cut out, because there are just way too many people. You're talking about testimony for multiple days, and it gets to an issue. What are the documents that prove that he does reside where he states to reside? And let the attorneys work together to work on the documents that will be submitted, as opposed to, I'm sympathetic to not, to A, there's time factor, B, things slip up, so that even if the objector redacts everything, you shouldn't have to go through that. But the attorneys working together to produce the documents should be sufficient.
So if I understand correctly, because there's a couple things that I heard, from what you were saying, Member Asfeld, you're requesting that the candidate and objector that the objector gets the documents, sends them over to the candidate, then the candidate does the redactions?
No, that they work together, that the candidate produce the documents and they can redact as they feel appropriate. The candidate shouldn't have to show the objector his tax returns, but there should be a way of working out a system so that the address of the different documents can be produced and verified and nothing else.
So you're saying rather than having a subpoena issued to the candidates, you're sort of saying more so they request to produce?
Yeah, but it's a subpoena to the candidate to produce these documents, and they can go into a closed room and make sure that everything's redacted, however they want to do it. But for us to go through each and every document and listen to all the testimony is very time consuming for something that has to have a fast turnaround.
I tend to agree that this is obviously a very large scope with a lot of documents that are being requested. Member Swanson?
This is a very large scope that's being requested. And that's why I suggested earlier, we need to go through each of these writers individually. And I think we can very simply eliminate categories. And I'm looking at the writer to candidate Harris. Okay, for A.
All right, before they get to that, let me just get to this real quick. We just got to do a little breakdown real quick. So she asked, well, did you Freedom of Information Court request the information? So basically he was saying some of the entities like the Park District or other entities may block his address, and which is true. It depends on the entity, and sometimes they pick and choose what they want to hold and redact, but it don't seem like he actually got that information. He said they had to verify that. So with that goes to say that was kind of like a proper argument. The tax filing, I'm gonna tell you that if you have a business and things like that, your tax filings is public. Like people can get to that and figure out how your business is doing, especially if you're on the market or things like that. So some of that can be found without them having to subpoena Napoleon to get that. I'm gonna be honest. Those are things that you could pay. You could pay a little something to get. So as far as them talking about the information getting out, like the social and all of that, a lot of the places shouldn't show that. It's more so to get the address. And when you're making a Freedom of Information request, it is better to be more direct as possible. So when you make, because they could deny, they be ready to deny it. So you can put like, okay, I'm asking for this information in regards to this particular officer trying to verify the address. You could just do it just like that. So there's some steps that could be taken to actually eliminate all of this buffer and all this extra talk. But I just wanted to highlight that. Now they get into that the candidates or the opposition to each other should work together to redact the documents, which is not really a smart idea. Okay, like this is it's very technical, but I'm gonna tell you, Napoleon lawyer extra. He extra with it, and he getting paid for his job. He said he gonna get paid. He gonna get paid.
State his driver's license and state ID card. Okay, copy of that. That shows an address. Lease agreements, is any and all? No. Within the last 2 years for the address I'm giving this court. Any and all records, man, that's way too broad.
Right.
Just, what rent payments he's made within the last year, if any. Insurance policies, that's not going to prove where he lives. That has nothing to do with residency. Utility bills, that doesn't show that he necessarily lives at any one place. So that D should be stricken, in my view. Or E should be stricken. Insurance policies don't show residency. Would not allow D. Utility bills doesn't show residency. His name may be on because he may pay the account on the house on Flossmoor while he lives in Hardy. So his name may be on there. It doesn't prove residency at all. For G, pay stubs indicate they've already got that information, so it doesn't need to be included in the subpoena. Leases related to the house on Dunfrey Street. I don't know if he leases that house or If there's a lease for his showing that he rents that property on Dumfries from somebody else, okay, lease effective within the last 12 months. Mortgage statements don't prove a thing about residency, in my view, so that should be, I think, deleted. Bank statements, same thing. J should be, it's too broad. It's not show residency. And same thing for K. Tax bills, we've already got that in the record. Some of it has been there, but they don't show residency. You may have an arrangement for whatever reason to property tax bill has his name on it, but doesn't necessarily prove he lives there. Same thing for the ungiveness court in Harvey. Property tax bill will go to the owner. If he rents the place, he wouldn't show up on that. So that doesn't show residency at all. Credit card statements, they don't show residency. That should be deleted in my view. Same thing for on loan statements. And P on those bills. And Q the same way. R the same view. They don't show residency. Vehicle registrations don't necessarily show residency. I don't see the validity in that one. Tax returns, maybe the last year's tax return
is good.
Only limited to showing the front of that where it shows the address, perhaps. Gym card, library card, park district card, I don't think that shows residency at all. So I would perhaps go through these other subpoenas in the same way. There's a very limited amount of things to Mr. Harris that I think are relevant.
Yes, I think you are correct that none of these.
The chair wants to add something really quick. Here, speak on the microphone.
I think the only disagreement I would have with my fellow board member is S is in Sam. I think vehicles are supposed to be registered to our home address, so that I would like to see, and it's probably easy to obtain.
You could do vehicles registered somewhere else. But they do, oh no, they do a lot of, I'm talking to myself. All right, so some of the things that the opposition is trying to say is not totally sufficient. I think they're saying some of this is to get Napoleon and his wife on there, because tax return is definitely something good to show. I think that should be sufficient. He don't have to show all the documents. It could just be the address, because that's usually how it is. Do people file tax returns with different address? Usually you have to show your when you deposit it. Everything usually have to match. So I think that's sufficient. Loan statements, people do fraud, and I'm not talking about Napoleon, but that maybe you could do a whole lot with loan statements. Vehicle registrations as well. You could get cars in different places. Things like that is not that hard, but you do need to actually have a license there. So you got to do a lot to get registration in other places. You see what I'm saying? And I don't think Napoleon doing all that. So some of these things I think were sufficient, but my synopsis and what I'm seeing, I think they're trying to force Napoleon to come and his wife to testify.
Okay, so none of these things individually shows residence, but what they do is if the water bill, the cell phone, the automobile statement, all of these things are mailed to the Flossmoor address. They make it more likely than not that he's residing there. And all of these documents have address information of the candidate. So if the candidate comes in here and says, I live in Harvey, but we show that the water bill, the gas bill, the cell phone bill, the bank statement, his tax return, all of those things have a Flossmoor address on it, then those are used to challenge his testimony that he lives at Harvey. And while any one of those individual things doesn't mean that he lives there, it does indicate that it is more likely that he lives in Flossmoor if all of these documents that he's giving to official organizations and to get mail that he has to pay bills from, if he is having all of that in the Flossmoor address, then that challenges his testimony that he resides in Harvey. So I don't care how many phone calls he made. I don't care who he made phone calls to. The only question is, where is his cell phone address? Where is his cell phone bill addressed to? Where is his bank statement addressed to? And the address that he uses on all of this official document, I believe, is relevant to where he resides, because he's going to put his residence address on these documents to make sure that he gets the things he needs to get in the mail, and he's telling people that this is where he lives.
And for the record, Ms. Kraftoffer also made some comments. She stated utility bills show usage of utilities, which would definitely show residency if there's no electricity or water being used for the property, etc. She also stated that municipalities require residents to have vehicle stickers. Those go to residency. Park districts have resident and non-resident fees, as do libraries, and those go to residency. If he has a resident fee in Fosmore Park District, then he is claiming residency there. And then I was going to ask Ms. Kraftoffer, it might just be easier for me to try and call her. So I'm going to just try and call her right now and see if that works a little bit better than this. So I'm going to put her on speaker.
All right, I think, let me see what she got going on. Did it mess up a little bit? I think her thing messed up just a little bit. All right.
2025.
Hold on. Shout out to Burgundy Blue. This is her live. I'm using her live because it's the safest live for me to use, and I appreciate her. But what she was saying, they get this before we get it started, that they can verify it based on the park district's bill. As you were saying, what's the difference between a library and a bill? The only thing is that with the library, like I applied for a library card out of my county, and like she said, the only difference is the fees for a resident and non-resident. So that would definitely show where is his actual address. But I was saying, ooh, because they was kind of saying that most of the documents, or from what I'm hearing, kind of aimed towards him living in Fosmore. But as I mentioned, I know it's a little portion of Fosmore that's actually in Thornton, but not a big portion. So let's keep playing this. So bear with any technical difficulties. Burgundy Blue did her thing.
Would be in deep trouble.
She did her
In
best.
my office. It is 2025. Everything's online. Okay. I have to tell you, if I was in a residency challenge, I would be in deep trouble because I live in my office. My vehicle registration for my personal cars come to my office. I live in a high-rise condo. I'm lucky if I see mail once every 2 weeks. My credit card bills are online. They have an address on them from 7 years ago, somewhere I lived 7 years ago. I don't believe there's much probative value considering everything's online. My bigger concern here is a subpoena gets issued. They comply with the subpoena after the hearing. And in that trove of documents from Chase Bank that they received are all the financial institutions, my client's business records, all this stuff. There's no protective order here. Listen, Scout's honor, I'm sorry, it doesn't apply here. These subpoenas are seeking information that no person would ever want to give up. And no court would allow it to be given up unless there was an issue involving a partnership or there was an accounting action. These subpoenas, the clerks that get them at JP Morgan Chase, produce the account statements, here you go, because that's what they're going to take. All accounts, all documents showing his address on it. Oh, go ahead, it's what it says is redact account numbers. It doesn't say redact transactions. That's what my concern is here. We can't control third parties and how they produce it. And I'm serious about this, is when I have a conversation with another lawyer during a hearing, you produce social security numbers and dates of birth, it's a public record. All right? I don't represent those individual voters whose private information has been produced out there. This is a campaign. All right? If you think Scouts Honors applies in campaigns, I don't think we just forgot what just went on with Trump Biden. Okay, that's what my concern here is. That, and when everyone needs to be candid here, I put it in my submissions. Ms. Peercrafter represents Christopher Clark, who's running for the same position here.
Oh.
So this is not just giving some other lawyer.
So that's what I was put up on by my favorite resident. And as y'all can see, that it's a small, small world. There's only 5 lawyers in Thornton and Dalton. Matter of fact, Illinois is just 4 of them taking all of the money. I had to sing, y'all. I'm a little silly right now. We're going to have to keep it spiced up. But this is what he just said. So Clark lawyer is actually the same lawyer who's objecting. And we're not surprised. Are we surprised? Because it's 5 of them. That's it.
We are giving the opposition that may get documents that are personal in nature. And that is my biggest concern. And these are so overbroad. And for that reason alone, we could tailor these down. I don't think these should be issued. If they want to go chase witnesses, go chase witnesses. You know, you want to get the neighbors next door, I'm totally fine with that. But when you start sending subpoenas to third parties, okay, one thing they didn't point out, concealed carry permit, your FOIA card, it's not discoverable. Okay, it's called the Second Amendment. Illinois been sued on this issue. So asking for that type of information, what relevance does it have? Because those are 10-year.
The Second Amendment is the right to have bear arms. The hell I got to do anything? Because he talked about a gun. 1, mouth. 2, guns. Remember that. The hell? I'm going to just tell you this. This guy is blowing a lot of smoke. I know y'all love Napoleon, but it's not about Napoleon. Now, y'all know they done leaked our all over. You know how many companies, even when we log on our phone and whatever, these in this disclosure agreements that just got our shit, and they've been leaked, and so much fraud going on. I don't know if he's afraid of fraud going on, but what is he afraid of? Who's gonna take Napoleon's social security number and shit like this? I think it's just a little bit outrageous, but he's trying to make his money. He putting up a good fight. I'm gonna just say that if I pay my lawyer, I want him to pull these shenanigans too. But to be honestly, a lot of this information that he's afraid of getting out, a hacker could get it. People sell it all the time, like Facebook, all types of shit. Our credit card companies, you know what I'm saying? They sell it shit. People just put it together.
Cards. My card has an address on it from 7 years ago. Have I updated my information with the state? Yeah. Have they updated it? No. I mean, so we're going to be in this mini proof period of, well, why didn't you change your address? Aha, we got you. That's what my concern is.
Madam Chairman, council points are well taken. I was thinking about the fact that things can be sent to a different address than where they resided. But for things that would be indicative of where he does reside, could we do an in-camera inspection? Would that have any problem? Just to look at the documents so that they are presented, they are held. We don't do anything other than to say, here's the address. Would that solve it? I don't want to go through a lot of documents that are not going to be dispositive. You know, at the same time, it should be fairly simple to determine where somebody resides.
I understand where you're going, and while I agree, I don't know that this board actually has the authority under the election code to do something like an in-camera inspection. And the reason I say that is because this board is bound by the Open Meetings Act, and I don't know that I'm not aware of any closed session exception that we could invoke to go into, say, a closed session to do an in-camera type inspection. And candidly, I work with the Open Meetings Act on a fairly regular basis, and I'm not aware of anything.
I completely agree.
So I appreciate the idea, the creative thought of, you know, how can we streamline this and figure things out. I just don't think that this board has the authority to go into a closed session type situation to do an in-camera inspection of the documents.
So objector, I thought Gary Lynn made a very good argument to put that in paragraph F. Can you possibly self-limit and suggest paragraphs that you would strike that Judge Swanson brought up? I don't think we need to see.
You're talking about the subpoena on the candidate?
Yes. Yes, in the paragraph F with the electric and sewer bills for Harvey. I don't know if I thought one would be relevant to Harvey would be. And then could you suggest possibly striking more personal information that really probably was sent online and not indicative of the address where it's sent, for bank statements, credit cards, and other personal information such as those? Are there paragraphs through you that you would suggest striking at this point?
That I would suggest striking.
Are you leaving it yourself at our mercy?
Something. Okay, I'm sorry, say that again, Gary Lynn. Try that again. I went to my Bluetooth. I got it. Try it now. Okay, so she says, hold on a second, sorry, still experiencing some technical issues. Can you repeat that? You said something about limiting it to 1 year?
Yes, we can certainly limit to 1 year. But because Mr. Malone's there, he can go through the individual requests and pare them down so they're more narrowly limited to addresses. But interestingly, what Mr. Residency is arguing is actually that it's your fear of a subpoena party producing too much information. And we'll be sensitive to that. I mean, we would agree to a protective order in that instance, and we don't plan to wait around private information in a public setting. We're also subject to ethics codes here. So to the extent that we will agree to a protective order not to provide that, that's certainly reasonable. It's just a residency case.
So unfortunately, this board does not have the authority to enter protective orders because the statute doesn't provide it.
I was actually just going to say the same thing. I don't, we have subpoena power under the statute, but I don't believe that this board likewise has the authority to enter any sort of protective orders. If anything, if the board is inclined to issue any subpoenas related to the bank accounts or anything like that, what I would suggest is a severe limitation on the scope of it and literally just basically subpoena saying, send us a document with the address, like send us
Thank you.
The front page of the subpoena, and that would, I think, be it.
I would agree with that. The problem is dealing with Chase Bank. The subpoena, most of it for the Midwest is in Indianapolis. I sent a subpoena in a case, limited it, and they produced way too much in a case. And it's just like, but there was a protective order in it. I had to advise the other side, return the documents. I should have never received these documents. That's what my concern is. And if this occurs after this hearing's over and the board is adjourned, which has been my experience, I get some responses to subpoenas after a hearing, and now I have documents floating out there. And like I said, we're all attorneys here. I'm not trying to besmirch anyone. I just have too much experience in this arena is when the political opposition gets something and it gets out there, and then we have to deal with it, and usually it's disastrous.
Okay, could just to answer the chair's question, if that's okay. You asked me what I would delete. If I could flip that question and say what I would think is most important.
Yes, that would be very helpful.
I think the vehicle registration.
Can you say the paragraph?
Paragraph S. I think when you file your tax return, you were saying that that's where you live. So the address on the tax return.
What paragraph?
That's paragraph T. Paragraph.
For 1 year? Is that 1 year?
For 1 year's tax return.
There, and just Attorney Otten just pointed out to me that in the subpoena writer, it does state that these documents would be for November 1st, 2023 forward. That's what you have in your subpoena. So I know there was some discussion about going back years, but it does say November 21st, November 1st, 2023 forward. So it's basically a 1.5, almost 2 year period.
Well, it's 1 year from the statement of candidacy.
Well, 1 year and a month, but okay.
It would be more complete if it all had an end.
He on it.
That if we're going to go along with that. No documents after November 1st, 2024. Only in that 12 month, put an end date on it. We can do that.
We could do that, yes.
Because currently it says to the present.
Yeah, I believe paragraphs O and P, which are for cable, I'm sorry, that's P and Q, which are for the cable and internet service at the address.
Why is P relevant?
Why does it show where he lives?
Because if he's getting cable at the Flossmoor address and not getting cable at the Harvey address, it's more likely that he lives in Flossmoor.
At the risk of being accused of arguing a point from Mr. Residency, which I don't intend to do because I want to get this limited down to what's relevant. How, if he has an agreement with his family that he will pay the bill for that, whether he lives there or not, how does that prove he lived there?
And I would also just offer that I tend to agree. I mean, my dad lives in Jonesboro, Illinois, and I pay his internet, I pay his cable.
But wait, if you pay it, I just gotta highlight that. This is one thing, but is your name on it? Because if I pay my older people's stuff, my name ain't on it. But maybe y'all doing some old school shit. You know what I'm saying? You know what we used to do back in the day. Not me, but you know what I'm saying. Use people's shit. It's just that right there is a little weird, but I'm gonna give it to you. This lawyer, she got caught up today in the Nate Fields hearing. The judge didn't spank her. She do a great job, but she be do suspect with some of the shit she say. But that's just how lawyers do. They be having a little angle, so I wouldn't put nothing past her either. I was just highlighting that. Let's go.
Show that there was service being used in Bloomsburg. There's no internet service in Harvey, is that correct? That's what I want to know. And maybe he has a phone that he doesn't. It's not absolute proof, but it'd be interesting.
Right.
I'm not interested whether plus one has to go.
Right, and then the utility bills E and F.
And again, I'm not interested in Flossmoor, I'm only interested in Harvey.
Harvey would be good.
So he's out, agree? You're saying you
Yes.
agree, okay.
Yes, and then for D, well, we'll skip D. I think A, B, and C, the driver's license, if he has a lease agreement in Harvey, and any receipts for payment of rent in Harvey, I think we all agree, you all agreed with that as well.
A, B, and C were left in by member Swanson.
These other bills don't necessarily, don't proving residency. He may have some agreement that he's going to be responsible for it and pay it, but it doesn't show that he lives there. And I don't think it goes to getting information that would be even under Rule 201 of the Supreme Court, leading to information that might potentially be relevant. I don't think it even meets that threshold.
But some of these items like, is it F? They're looking for not for the address of the usage. So if you have a zero electric bill, you need that.
Even if the electric or sewer bill, utility bill shows usage, if the family lives there, he's responsible for it, even though he doesn't live there. What does it prove? It doesn't prove he lives there.
The one at Harvey would prove that there's no usage.
I think their argument is it's vacant.
I'm actually talking about Flossmoor address.
No, I'm not looking at anything plus.
Okay, so for the record, I think to streamline this, is the board in agreement that it does not want any subpoenas issued, or it wants to at least limit the scope solely to the Harvey property, not the Flossmoor property? Is that what the board is desiring? Okay, so then I think that
it's in Harvey.
Go through this really quickly. Let's eliminate those.
And that
and
holds, in my view, holds for all of these drivers, and not just the one we've been discussing.
Right.
I think we could summarize the paragraphs he limited to, which were A, B, C, F. And correct me if I'm wrong. From F, do we go to, well, can you recite the paragraphs in a row of what you're leaving in, and then we can go down those paragraphs?
Okay, so C, F,
Not G, but Q.
Q.
Q, S.
Well, let's let Ed make his, or Mr. Mullen make his statement.
Dang, that's a lot.
And then T.
So A, B, C, F, Q, S, and T. And U, if everyone says. So A, B, C, F, Q, S, T, and U is what the objectors are agreeing to limit the scope of their subpoena.
Would
And then
you
T would just be we'll add the November 1, or sorry, November, what was the statement? Statement of candidacy was filed
In December?
December 6th to 16th. So we'll say it ends on December 16th, and for T, we just want the date for the address.
What's the year?
So November 1 to December 16th? November 1, 2023 to December 16th, 2024.
Okay.
Okay. So again, just for the record, what Mr. Mullen and Mr. Craftheffer are proposing is to limit the subpoena to Napoleon Harris to include items A, B, C, F, Q, S, T, and U, and to further limit it to the dates of November 1st, 2023 to December 16th, 2024. How does the board
Can we
feel
ask
about?
the candidates response to that?
Sure. Mr. Lexi, Mr. Sackler, Mr. Tanner, do you have any response to that?
So with regard to tax returns don't have to be to your residence. I do them for clients that go to businesses, personal returns.
You're gonna get in trouble.
And once again, all that is filed online. It's no longer through the U.S. Postal Service. With regard to these other ones, you're going to roll the time period's fine as far as the limiting the time period.
So you're in agreement with the objector to all of his subpoenas?
I would say he's in agreement.
No, we didn't, no agreement. You're going to issue a subpoena, authorize the issuance of a subpoena that's going to be modified, that's going to just have A, B, C, F, Q, S, T, and U. My biggest concern is on the tax returns are, I don't know if my client's under an extension, so there would be no page number. There would be no, you just file the electronic extension under the Social Security numbers.
And realistically, would we get a response by next week from the
Well,
IRS?
well, let's keep in mind, this is not a subpoena to the IRS. This one is a subpoena to the candidates. So these are documents in the candidate's possession or the candidate's control. Right, well, if he hasn't, I think is what Mr. Lexi is saying, is if he hasn't. He may have filed an extension, maybe he didn't, who knows. And I guess I would just say, as it relates to, Mr. Lexi, Mr. Sacramento Centeno, as it relates to any sort of privacy concerns, what I personally have done in the past, when I've been representing candidates that were objected to, is I literally redacted every single thing on there except for the address. And I used a computer programming redaction, so you can't hold it up to a light and see through it or anything like that.
I make sure I complete that process.
Okay, so is the board in agreement to issue the subpoena for Napoleon Harris for items A, B, C, D, F, Q, S, T, U from November 1st to November 1st, 2023 to December 16, 2024? I think that they want to offer.
D is not.
Oh, I'm sorry, D is not. You're correct. I apologize. I misstated that. So let me restate that. A, B, C, F, Q, S, T, and U.
So
Okay, and do we have a second on that? Okay, I will call the roll. Chair Raymond?
yes.
Member Swanson?
Yes.
Member Oswald? Okay, so that subpoena will issue. I guess how do we want to do this to get the signature of the subpoena? I guess the board chair can sign it today, but I don't want to issue it until we have a revised writer. So do you guys want to, or maybe the better way to do it is just, okay. If you're done while we're sitting here, email it to me and I can have the clerk's office print it and we'll get it to you so you can get it issued straight away. Otherwise, my suggestion was going to be send it to me and Chair Raymond can just electronically sign it, send it back, and send it to the parties, and you guys can distribute it and serve it tomorrow. So, okay. All right, moving on. I think that the next subpoena that the board wants to review is the subpoena to, and we'll just kind of go in order of packet, just to make it easy for everybody. And this is a subpoena to the Forest Ridge Academy, which I believe that the objectors are making an allegation that this is where the children of Napoleon Harris, or some of the children of Napoleon Harris, attend school.
I move we deny that.
Is this the showing the address on file?
This is to show an address on file. Again, it's just to show what address they're saying that they live at, other information.
His children may live there, maybe he doesn't. I don't think it proves residency for Mr. Harris at all. That's why I would deny it.
I understand that, but he's going to come in and testify, and this is cross-examination material, and I think it's relevant and appropriate. And Mr. Ladizinski, I made the same objection, and Mr. Ladizinski got this information in the last case we were.
No, I didn't.
Yes.
No, I didn't. I requested from your client, Thaddeus Jones, who happens to have a home in Garden City but lives in the village of South Holland with his wife, and he was asked to produce documents that he had received from the school with the address, not the school. I asked the candidate.
I just made that face because just the other night I just happened to pull up that old article of Thaddeus Jones going after him. You're talking about she's stealing. You remember I just kind of flashback? That's weird that they bring it up and highlighting that they got 5 lawyers. This same lawyers connected to Clark, Thaddeus, and the people who are objecting Napoleon. This is weird. This is weird. Let's just keep this moving. I heard that. I was like, whoa. So I got to do some more research on Thaddeus, see what he got going on, because his name's starting to hit a little bit for some apparent reason.
There's only 2 subpoenas. There's actually 3 subpoenas issued, one for his wife at South Holland, and 2 witnesses that other city employees that lived at that residence that he claims was his.
Member Oswald, do you have any input? Oh, we're not on a motion. We are just discussing right now the subpoena to the forced. Oh, you did make a motion. I'm sorry. Oh, denied. Okay. So we have a motion to deny the subpoena. Is there a second? For lack of a second?
Forest Ridge Academy.
Or Forest Ridge Academy. Thank you for the correction. I was just trying to make sure I have the right.
Denied. That's right.
I would allow it. I realize he may not live with his wife and children. I have no idea the family situation, but that's something maybe we can find out in testimony. So I would be interested in the school records.
Okay, so as the electoral board attorney, I just want to say that, you know, and also as a parent myself, I do have a lot of concerns about a subpoena going to a school, asking for any sort of information about children. I feel that children, honestly, should be left out of this process. I think that you get, especially this is a private school, this is a public school where you have to be a resident of that district to send your child there. These are private schools. I think that there's a big difference. And I think that my personal opinion as the electoral board attorney, I think it's opening up way too big of a can of worms. I think there's better ways to find out this information.
I'll respect your opinion, and I did not realize it was a private school, not restricted by district.
Okay, I just gotta ask y'all a question. I never really asked who this lady with the scrunchie hair. She a lawyer? Could y'all clarify for me? I know we got some Thornton and Dalton residents in here. Help me out, booze. Cause her little scraggly hair is saying too much tonight. She's saying too damn much tonight. The hell? And it didn't make sense. Yes, and I guess she didn't know that it was a private school. Private school, you don't have to live in a district. And then in Georgia, in our state, sometimes you got kids' choice too. So the kid could be in another district. But I mean, it's just to get the damn address. Why is it so fucking complicated? This is getting disgusting. It's extra. Let's watch it. I'm going to get off the screen so I can get my pillow because my back hurting. Hit the like button. I love you guys. This is my third live tonight. Look, my third live tonight. I'm just playing. I love y'all. I may put the panda head on if I have some energy. Hit the like button.
So you can, I mean, if Member Swanson wants to remake his motion.
Second.
Okay, so we have a motion to deny the subpoena for,
Forest Ridge Academy.
thank you. I keep wanting to call it Forest Ridge Academy. That motion was made by Member Swanson and seconded by Member Raymond. I will call a roll. Before I do that, is there any further discussion? Okay, Chair Raymond?
Yes.
Member Swanson?
Yes.
Member Roscoe?
No.
Okay, so that carries as a denial of that subpoena 2-1. Okay, so the next subpoena that we are looking at here is a subpoena to the Illinois Secretary of State. That subpoena requests the driver's abstract for Napoleon Harris at both addresses, both the Flossmoor address as well as the Harvey address, vehicle registration for any vehicles in the name of Napoleon Harris III, a copy of the driver's license for Napoleon Harris III, and a state ID for Napoleon Harris III.
Got a small.
I move that we grant that request.
I think it should be limited. If it's motion is limited, I might consider seconding it. Driver's abstract, I think is totally irrelevant to prove residency. That would just show if if he's ever received a ticket or been involved in vehicle collision, received a ticket. Vehicle registrations and driver's license and state ID arguably would be okay, but not paragraph 8.
As the electoral board attorney, I would tend to agree with Member Swanson. I don't think that a driver's abstract actually shows anything as it relates to residency. It just shows whether somebody's potentially a good driver or a bad driver and how many tickets they have or do not have. And I don't think that that's relevant. I think that the information related to the address can be found both on the vehicle registrations, the driver's license, and the state ID. I see no probative value for the driver's abstract.
So I'll amend the motion to allow for the subpoena to go to the Illinois Secretary of State for the vehicle registration, driver's license, and state ID, and not to the abstract.
Okay, and would that be for both addresses, both the Flossmoor and the Harvey address, or?
Correct.
Okay, so we have a motion on the floor to grant,
So
oh, I'm sorry.
if I want to make sure that this is limited to these two addresses. He has a business, there's vehicles that are registered in multiple businesses. So that's what my concern is.
It's limited to those two addresses. And I will say, from my history with my father who sold auto insurance, I think that you can get in big trouble to claim to live one place and not live there when it comes to an accident. So that if somebody claims to live X, has an accident, the insurance company, they may very well deny it. So it's much more serious than just getting your bank statements at your office.
Understood.
And we don't have a limiting mandate.
They will. The 16th, is that correct?
Yes.
Okay.
That's my understanding.
Yeah, that was what I understood as well. So we do have a motion on the floor to issue the Secretary of State subpoena, but to strike A on the writer, which is the driver's abstract. So it'd be limited to the vehicle registration, driver's license, and state ID at both the Flossmoor and the Harvey address. And that motion was made by
Vehicle
Member Osborne.
registrations just limited to the Flossmoor and Harvey addresses specifically. So would not include, for example, if there's a vehicle registered to the pizza parlor, which is across the street from the one lady claims to reside.
I think you're getting part of this. My client is a former NFL player, and he is supporting many of his family members. I don't want that information out there. And it's already out there now because it's a public meeting, but that is one of the biggest concerns I have here.
Understood.
So with those, Mr. Residency, just so I understand your point, does that mean he may have vehicles that are in his name personally that are really for the use, sole use of a family member potentially?
His name may appear on vehicle registrations with that other family member.
Okay. Wow.
That's what my concern is, like, someone couldn't afford to purchase a car.
But the request is limited to the two addresses.
Well,
I mean,
so I think, I guess, Mr. Mullen, if you get anything that is unrelated, I mean, I understand,
I go back to my concern here, this is politics.
wait, that was stupid. I'm gonna just be honest. Napoleon lawyer just said something stupid. Like, okay, why would I put Napoleon on my insurance in my house if he's not in my household? That will cause my insurance to go up depending on his driving history. I know that because I was trying to get my daughter, like, they was like, yo, she has to be on the insurance because she live with, no, she don't live with me. And it made my policy go up. So people won't opt to do that. Now, if the person can't get insurance and Napoleon puts them on his insurance, which makes more sense, it should be at the primary address where all of his vehicles are registered at, because if you have one vehicle in one address and you have 1,000 vehicles, usually they do it at one address. Who registers vehicles in different states, different address? That's not even legal. I mean, as far as different states in different, it just doesn't make sense. His lawyer is doing his job. Oh my God. But some of his stuff is like this bogus right here, right there, right there. Let's play. Let's play.
They represent an opponent in this race.
That's
Okay?
Do you want the subpoenas to be returnable to me?
Yes, I want all the subpoenas returnable to the board.
And then I'll just distribute the
his opponent.
responsive stuff after a quick review to make sure that there's no issues, and I can.
Oh, Clark.
I can even send it out in a protected PDF, a password coded PDF. That could be a potential solution. Just try to figure out a way forward that everybody feels comfortable.
I think there should be any vehicle registrations solely in the name of Napoleon Harris at those two addresses.
It is. It says it says vehicle registration in the name of Napoleon Harris III, driver's
So-
license for Napoleon Harris III, and state ID for Napoleon Harris III, and it is limited to the two addresses. So, but if the parties would like it, have the subpoenas returnable to me, I'm fine with that. Obviously it's gonna increase my workload, but, that would make everybody feel a little bit more comfortable as to the sanctity of the documents. And like I said, when I do send them out, I'll send them out password protected. Is that okay with the board?
It's fine.
Okay, I think that is possibly at least a fairer solution. And if that way, if the subpoena of the Secretary of State comes through and it's got a different address, I will alert the parties that it came through with a different address, but I'm not going to be giving it to everybody because it's not responsive to the subpoena. Okay, I think an elegant solution to a complicated problem.
Could we take a 5-minute break?
Yes, I can go with myself.
Okay. All right. I kind of understand that. I mean, I understand that because if you register your business at the Secretary of State in with another entity address, sometimes people do that. You don't register your business if you don't have a physical place. People sometimes use third parties. You see what I'm saying? So that makes sense. So they like, if that comes up, then don't share that information with them. It's good that the lawyer is going to be the person that received all the subpoenas from what I was hearing, and then she's going to divvy it up. They were asking for that man abstract. They were asking for that. That's just ridiculous. Some of the things were egregious, just like you were saying. And again, thank you guys for being here with Grace Levi. You already know that this is a recap. It played earlier. A shout out to Burgundy Blue for being there. You know what we do here. We watch it, we break it down, we pay attention to details. Sometimes we see things that you didn't see in the beginning. Sometimes I say stuff, sometimes you do. So we put the pieces together here as a family. You know what I'm saying? And look at things critically. So you're open to be in the chat. As long as we're respectful to each other, you already know we got honeymoon on it like kryptonite. And I am too. I'm not really about to play too much. I love you guys, but I ain't that sleepy. Love you. Shout out to all the new people who came over to check me out. Thank you so much. Thank you for the people who are revisiting. Just remember, be on your best behavior. We all on neutral terms. You see what I'm saying? I love you guys. I'm watching in the chat. All right, let's fast forward. 5-minute break. Shout out to Burgundy Blue.
Be interesting.
She's
anybody
comments.
Scott, what is he in there doing? Scott cutting up. What is Scott?
The best thing about watching it over, you get to fast forward the shit. Fast forward. Fast forward.
So
let's go.
It does say we demand your appearance. All right, so we ready to go back on record?
Fast forward.
All right, is everyone ready to go back on the record?
Yes.
Mr. Rowland?
Yes.
Okay. All right, so we are back on the record. We took for the record, we took about a 5-10 minute short break. Where we last left off was we were discussing the subpoena to the Secretary of State. I believe that all the parties have agreed that not only will the subpoena be limited, but all responsive records to all the subpoenas will come to me as sort of a clearinghouse, as the electoral attorney. I will review the responsive documents, and if there's anything that I think is not responsive that's outside the scope and that invades privacy, that is again outside the scope of the subpoenas, then I will return that to the sender and say that this is not responsive, we don't want this.
So I just want to be clear, with regard to these subpoenas, many of them are asking a human to come to testify with the documents. So I don't know if you'll be receiving any documents.
So that is a fair point. I mean, the documents from Mr. Harris, I don't need to see those before. You're his attorney, you're going to control those. I think we're talking about the third party subpoenas.
After these sort of.
Correct. And we're talking about the third party subpoenas. So, you know, as it relates to those coming to me. So are both parties in agreement that the third party subpoenas, not the subpoenas for the candidate or any other family member, if those issued?
By him.
Correct.
By him.
Yeah, so for the Secretary of State one, it does say we demand your appearance, but as we all know, it's really a subpoena for documents. So in fact, if you can just, I know that that's the traditional language we use in subpoenas, and I don't really understand why, if it's a subpoena for documents. If you just want the documents, why you have to demand the appearance?
Well, because you need foundation.
Well, true, but if they're coming in through subpoena.
You need foundation.
So you're gonna want somebody from the Secretary of State here to testify to?
There's ways of doing it.
Okay. All right, well, either way, we'll have them returnable to me. I would put I guess that begs the question. We've got the next hearing date as the 31st. But if I'm gonna review these in advance of that, then I'm gonna need them by the 30th, but we don't want them to come in early on the 30th. So how do we want to do that? So what I was saying is that the next hearing is the 31st.
Right.
If we want me to review them sort of as a clearinghouse and them come to me and then we distribute them and have it be returnable to me, then what
they're returnable here.
Correct.
Except for the ones that are for documents only, and there are not that many for documents only.
So with those, the ones that are for documents only, such as the Secretary of State one and some of the other ones that we're going to be going through, I think we need to adjust the return date on that and make it not the 31st and give me a day or two to take a look at it and then get it to you guys. So I was just going to say the 29th. Are you?
It's 3:20 on Friday. So if I I'm the Secretary of State. I'm not going to be served until Monday morning, and you're giving them less than 48 hours to respond to this.
Do we want to say the 30th then? I'm just trying to figure out a way forward, otherwise we can use the next hearing date to kind of go through the responsive documents, and I don't think that's what anybody wants to do. I think we want to get to the hearing on the 31st. Right, so.
Don't offer.
Well, I'm just trying to figure out a workable mechanism. If we're gonna have the subpoenas returnable to me, but how about this? How about, let's finish going through the subpoenas. Why don't we do this? Why don't we finish going through the subpoenas, and then the three of us can figure out how we want to make this happen.
I've never seen a Secretary of State subpoena come back any thicker than this.
But we can just keep it on the 31st, and I guess whatever comes in, I'll take 5-10 minutes to review, but that's not gonna give anybody any opportunity to make copies and stuff like that, so.
Thank you.
Okay, all right, then we'll just make it on the 31st, if that's.
Yeah, I mean, if you take a look at the subpoenas, my concern are, they say you provide these documents ahead of time, your appearance may not be required. So I don't want documents just being sent unless they're going directly to you.
Okay. Then we'll make it returnable to me, but we'll keep the date on the 31st. Okay. All right, so, Dan, when you are drafting those over there, if you could make them returnable to me at my law firm address, which is 1441 South Harlow, Berwyn, Illinois, 60402. And if you need to put a phone number on there, you can put my office phone number, which is 708-222-7000. Yep. Okay. All right. Moving forward. So now we need a motion to approve the issuance of the subpoena for the Secretary of State, limited to items B, C, and D, and only covering the Flossmoor property and the Harvey property. Do we have a motion to that effect? Okay, we do have a motion from Member Swanson to issue the subpoena as modified and as discussed. We have a second from Chair Raymond. I'm going to call the roll. No, I'm sorry, second from Member Oswald. I apologize. I will call the roll. Chair Raymond? Yes. Member Swanson? Member Oswald? Yes. Okay, the subpoena will issue as discussed on the record.
And I move we approve the subpoena to Dolores McGee as drafted.
No, we're going through the packet.
Oh, I missed the page? Oh, I missed the page.
Okay, so we do have a motion from Member Swanson to issue the subpoena as drafted. And just for the record, this is a subpoena for personal appearance, correct?
Yes.
And this was the neighbor?
Yeah, this is the person in the house adjoining the Harvey address.
This is too much.
Not the neighbor, y'all.
Yeah, that's what I just said, Blue. I said
Okay,
this.
so we have a motion from Member Swanson, second from Chair Raymond to issue the subpoena to Dolores McGee as presented.
Wow.
Do the roll call. Chair Raymond?
Yes.
Member Swanson?
Yes.
Member Oswald?
Yes.
Motion carries. That subpoena to Dolores McGee will issue.
Right, we will withdraw the subpoena request to the Illinois State Police.
Okay, I will note that on our packet. Obviously, I'm assuming that the Candace Council has no objection to the withdrawal of that request.
I have no objection to that.
And we'll remove our request for sanitation as correct.
Okay, duly noted. And Candace Council, no objection, I assume?
No objection.
Thank you. The next one we've got here is National Passport Center. All I gotta say on that one is good luck.
Wait a minute. We have A to Z. Oh my God, this is a lot of subpoena, y'all. Y'all know I'm just watching this. Oh, we getting down to it though. Jesus, A to Z. They even said the state police records. Maybe that was for his gun license. Oh my goodness. I gotta sound like my Haitian grandma. I had to put my pillow behind me for this one. Let's finish. Hold up. Do y'all know who's getting subpoenaed at this point? Can we just do a recap real quick? So they limit the subpoena to being between the dates of whatever they were requesting between November 2023 to December 16, 2024. Only to be limited to the Flossmoor address in the Harvey. If anything else come up, they are not to see it, not to talk about it. And it's not supposed to be shared. It looks like, y'all can verify with me, but it looks like the wife is being subpoenaed. Two city employees is being subpoenaed. Information from the Secretary of State is being subpoenaed. Driver's license / ID, no abstract being subpoenaed. Third party, as they just talked about, the neighbor. What this is the YSL trial. They done pulled everybody up in here. Everybody. So shout out, thank you for asking that question. And thank you for you guys educating each other in the chat, because that's what we're here to do. You know what I'm saying? So I appreciate you guys. All the new people, welcome to my channel. Please feel free. No comment, no question is stupid. As long as we just respect each other. You know what I'm saying? Let's go. First, Jesus.
I don't have authority to withdraw it or to postmaster, but I don't expect a response.
I get a fathom that they can't turn out passports in a timely manner. The responses to subpoenas may take a little longer, but I don't know. I've never tried it.
You do not have jurisdiction to issue subpoenas out of this jurisdiction.
Yeah, look.
And truthfully, I mean, my opinion is I think that there's enough documents here that are subpoenaed. Otherwise, I don't know about the jurisdiction to issue the subpoena outside the jurisdiction. That's something I would have to look at. I think that he's saying that we can't issue subpoenas to national agencies, only things within the state of Illinois.
Yeah. Uniform enforcement subpoenas only applies to subpoenas issued in litigation matters that are pending in courts. They do not apply to administrative subpoenas.
You want to withdraw that knowing it's not going to happen?
Yeah, let's withdraw that to the postmaster and the Carl Washington.
We have no objection.
Okay, so give me a moment. Let me.
Passport office was withdrawn.
Yeah, that is withdrawn. That as well as the postmaster. So we are now in the subpoena for Carl Washington, and candidates counsel has indicated no objection to that. So the subpoena to Carl Washington, we just need a motion to approve the subpoena.
Carl Washington.
So moved.
Second.
Got a motion by Chair Raymond. I'm sorry, yeah, Chair Raymond and Member Swanson, and second by Member Swanson. I'll call the roll. Chair Raymond.
Yes.
Member Swanson.
Yes.
Member Roscoe.
Yes.
Motion carries. That subpoena will issue.
No.
Oh, that's
my
the
clarification.
subpoena.
Passport subpoena withdrawn.
Yes.
And the one that the postmaster does.
Correct.
Those are both withdrawn.
Yes. Okay, so moving forward, we are now in the subpoena for Nicole Harris.
Who is it? That just look at it.
That's the wife.
Now.
We would ask that be limited the same way as the subpoena to the candidate.
As I am drafting that now, specifically, that would be to paragraphs A, B, C, F, N, Q, R, and S.
And they were identically worded to begin with.
They're the same as you approved to the candidate.
The subpoenas were not identical, and that there are two more paragraphs in Napoleon Harris, but the letters I just named correspond with what was previously approved.
So,
yes. A, B, C, F, N, Q,
M.
R, S.
Where's the M come from? M.
Pardon me, this is why we were doing this. I believe we would have left in O, is that correct?
What? No. Wait.
Now, these are her name and that. Correct?
You're getting on my nerves with
This
these
is
things.
her driver's license?
Yes.
I mean, does the board see the relevance? I mean, if we're already getting the
I don't see the
subpoenas.
relevance to her driver's license to his residency.
We don't know their relationship.
It had,
My
yeah.
recommendation would be to deny the subpoena.
So moved.
Deny the subpoena entirely?
Yeah, to Nicole Harris. I don't see the relevance of subpoenaing his wife as it relates to her. I mean,
But
like the board was saying.
she knows where he lives. She knows where he lives, so she should be able to testify to that.
But these documents.
Okay, then we'll take the rider off, but we want her here to testify.
Okay.
Okay, any response, Mr. Residency?
Malicious mischief. Malicious mischief.
It's gonna be my.
What does the board think on this?
Yes, I would like to hear from Nicole as to where her husband lives. So how do you word that?
So, The wording would just be to issue the subpoena for personal appearance. Okay, so we have a motion by Member Raymond to issue the subpoena for personal appearance of no right. Member Oswald.
Yes.
Okay, the subpoena for Nicole Harris will issue solely as to her personal appearance to come testify.
She coming. This is psyops. This whole Thornton Dawson thing is a government psyops. It ain't real. I'm just playing. No, this is officially a soap opera. His wife got to come. This is the story that keep on giving. You know we're gonna be there on the 31st. Please let Burgundy Blue be there. Shout out to her. Shout out to these clips. This is so much clearer than the live. I'm enjoying this. This is out of pocket, but we're learning a lot here. And HBAG, you asked there's a few questions that I just want to get to. You said, do subpoenas have to be approved by the judge? Yes. Well, yes. And also that's just like a search warrant. And in here, it has to be approved by the board. So shout out to you. Status quo, I have to say with this one, I second that notation. But I'll be having this be quiet. Not on my chat, though. You guys can talk and say what you want. You know, as long as we keep it respectful. But myself, you know, I'll be riding the waves. And they like Grace Levi, they don't. So I appreciate you, status quo, because that's what they told. That's how it is in Haiti. We put the people first. So anyway, also hustle. I just got to put it up there. Oh, man, y'all hitting them up. And, you know, I'm just hitting it now because at the end, I'm not hitting all of these great comments, but I'm doing it now. You see what he said? You see what he's out. K Hustle, I'm just going to put your comments up there. And I'm just going to be quiet. I respect your opinion. Don't know if it's totally true because I didn't get to see the picture with him in front of his house, like you said. But yeah, let's move forward.
I was just going to move over to that one. Mr. Mullen, what is the plan on the Bank of America loan?
Sorry, which one?
We're on Bank of America.
Okay, we'll withdraw that.
Okay. And I assume no objection, Mr. Residency?
No objection.
Okay, thank you. And next one is Homewood Flossmoor Park District. That's one that the objectors had stated that they wanted to keep based upon the reasons that Ms. Craftheffer had stated on the record related to resident rates, non-resident rates, and so on. I do know for the record that the scope of the subpoena relates to both the Flossmoor address as well as the Harvey address, and it states any and all documents such as membership documents that reflect the address of Napoleon Harris III, any and all documents such as membership documents that reflect the residence of 1405 Dumfries, Flossmoor, Illinois. And again, this is to the Homewood Flossmoor Park District.
It does not have a relevant time period.
That is correct. I don't see any sort of limiting time period on here.
Well, we're happy to do that. We're just asking for what the current address on file is, so it doesn't go back in time at all.
You want today's address? Are you looking for the current address today or the address when you filed the statement of candidacy?
We'll put the time period in there.
Are you talking the November 1st to December 16, 2021?
So, yeah, I mean, my only concern was, you know, he might have filed his application 4 years ago, right? But it's current as to what his address is now.
It is not the role of this board to help the objector redraft subpoenas. I mean, the rule provides your draft subpoenas, and these should be denied outright. If you can't get it right for the time period, and we're going to spend this time helping Mr. Mullen draft them correctly, Ms. Carecrafter, I have an objection to that.
Understood, point taken. How does the board feel about that?
I think we can limit what we approve in a subpoena. I don't think our hands are tied to put a date restriction. And I think we said at the beginning that that date period would apply to all of the subpoenas, but we're just saying.
No, and we said we'll add that, yes. But I was just explaining we didn't necessarily.
Yes,
I didn't include it in the original because the application might have been previous to that, but we'll add that limitation.
There's a question I have because it's referring to all people who live at that address. And I would go to only the candidate because if the claim is that he's living there with his family, you're talking about children. Children shouldn't be involved in any of this. So I would move that it is accepted to the exclusion of anybody other than the candidate.
So you would eliminate B and keep A.
You eliminate B from the writer?
I don't have a copy of that. I don't have yeah, I would eliminate B.
Okay. So any other board members have any comments?
Am I looking at the right writer with B
Yes.
concerning Flossmoor?
Yeah, it's, yes, because this is a subpoena to the Homewood Flossmoor Park District.
Oh, I'm sorry. Okay.
So Member Oswald has suggested the elimination of B. So Member Oswald, since that's what your suggestion is, do you want to make a motion to that effect?
I move that we allow the subpoena to the Homewood Flossmoor Park District with the exception of paragraph B and for the time stated.
Certainly the deadline of time. I'll second it with that modification.
Okay, so just for clarity, so that all the parties are aware, the board has made a motion to issue the subpoena, however, only as it relates to item A in the writer, and to limit the scope of the subpoena to November 1st, 2023 to December 16th, 2024. So we have a motion on that. I'm sorry, Member Oswald made the motion, Member Swanson made the second, so I will call the roll. Chair Raymond?
Yes.
Member Swanson? Yes. Member Oswald?
Yes.
Motion carries.
And so with respect to the next one, which is the Flossmoor Public Library, we will voluntarily agree that that would be the same as the Park District.
So we're taking out B.
Yes, and
I'm limiting the scope of time.
yes.
Does the board, how does the board feel about that? Does the board want to make a motion?
Yes, I will.
So moved.
Okay, so just to be clear, there's a motion on the floor to approve the subpoena to Flossmoor Public Library with the limitation of removing item B on the subpoena and the limitation of the scope of time from November 1st, 2023 to December 16th, 2024. Do we have a second on that motion?
As modified, I'll second.
Okay, thank you. I will now call the roll. Chair Raymond?
Yes.
Member Swanson?
Yes.
Member Oswald?
Yes.
Okay,
The next one is for the Village of Flossmoor for the parking pass that is only for residents, and we would request that that be approved with the same modifications as the last two.
And for the record, the subpoena requests any and all, and it doesn't have a time frame, but as we discussed, we're limiting all of these to November 1st, 2023 to December 16th. The subpoena requests in item A, any and all documents such as vehicle stickers or applications for vehicle stickers that reflect the address of Napoleon Harris III. And B, any and all documents such as vehicle stickers or applications for vehicle stickers for any residents of 1405 Dunfrey Street, Flossmoor, Illinois 60422. So just to be clear, you're also going to remove, or you're saying that you'll remove item B, so it's just item A.
Correct.
Okay. So this is similar to the last two that the board just did. Does the board want to issue the subpoena as? Hold on, Mr. Residency has a comment.
The objection I stated before, if he's paying for someone's vehicle sticker on a vehicle that may have made purchase for someone as a family member, I mean,
You could testify to that, but I think we're still entitled to the document. In order to get a parking sticker, you have to show that it's your car and you live there. So it's relative.
but if a relative comes in, a relative is living in Flossmoor and gets a parking sticker, and Mr. Harris's name is also on there because he's on the title of the car, what does that have to do to prove that Mr. Harris is living in Flossmoor?
So won't you explain that to us at the time then?
This is exactly what I'm concerned about, is my client have to testify about what I would say generosity and good deeds. I was always taught about generosity does not have to be something that you should be talking about publicly, you just do it.
Are they limited by address of the person?
It depends on the municipality.
Yeah, it says Flossmoor residents must purchase and display a vehicle sticker to every vehicle that is registered to or housed within the village. So it says Flossmoor residents must.
That's limited to registered on the Dumfries address.
Yes.
Yeah.
Is that acceptable, Mr. Gladys?
That's acceptable. We'll see what the document that gets produced has.
One another one is for Colonel 2000.
Yes.
And, you know, one other thing, if I could just go back really quick, what I noticed in the last couple subpoenas, and I apologize for not noticing this, in regards to the writer, when you guys are sending back the writers, as it relates to the ones that are going to Flossmoor, like the Flossmoor Park District, Flossmoor Village, Flossmoor Library, you do still have a Harvey address in the opening paragraph of the writer. It says, you know, you,
We'll take that out.
okay, all right, just want to make sure that that was noted. Okay, so then if you could also, we'll have the board vote on this momentarily, but my understanding from what I just heard from the board is that they're okay with the Village of Flossmoor subpoena, provided that it's limited to the Dumfries address.
Yes.
Okay, so,
On that, I think we may do a motion.
no, I think it's, but we made it clear on the record. I think it's clear enough on the record. If they come through and it's not consistent with what the board has discussed and ordered, then I'll just send it back and say, fix it. Okay, that said, if we can have a motion to approve the subpoena as modified and as discussed. So we have a second?
Second.
Chair Raymond?
Yes.
Member Swanson?
Yes.
Member Oswald?
Yes.
Motion carries. Okay, the next one is Nina Graham.
And this is solely a subpoena for testimony from someone who is a personal friend of the candidate and has where he resides.
Was there an objection to this?
I think with regard to O, P, Q, R, and S, and
There's no writer.
Where are you getting that?
there's no writer to any of them, so I'm assuming these are just personal appearance.
Yes.
Subpoenas for people to testify, and that they believe that these people may have information.
That is correct.
So you have no objection to the Nina Graham subpoena?
Malicious mischief, go at it. I know they will not be very happy with Ms. Graham's testimony.
Okay,
You know what? I'm just gonna say this. This is just in my mind. Before this part came up just now, I was like, why they bring up maybe somebody else and have them on a assurance policy, and they really restricting it to these two addresses, which is understandable. Like, I'm thinking like, okay, is this fraud? But then it popped in my head like, damn, maybe Napoleon got another girlfriend or some shit. I don't know. It just popped in my head. And then all of a sudden that Linda Graham come up. That's why I was like, ooh. But that's just my speculations. I don't know. I don't know what brought this to my head, y'all. But if something come up like this, y'all better say Grace Levi is psychic. I don't know. But it literally came to my head just before they talked about this woman. And the guy was like, now, if that is somebody allegedly that he messed with, because that's his friend, he said it'd be funny for Napoleon lawyer to be like, I object. And he didn't object to the wife. You see what I'm saying? So, and then he like, yeah, you ain't gonna like her testimony. So I want to hear. Oh my God, girl. Oh, I'm sorry. Let's get back to it. I had an epiphany. I'm about to pass out. This is allegedly.
we have a motion from the board to issue the subpoena to.
So moved.
Okay, so I have a motion by member Oswald and a second by member Swanson. Chair Raymond.
Yes.
Member Oswald.
Yes.
Member Swanson. Motion carries.
That was the,
Nina Graham.
Okay.
Correct. And this is that's a personal appearance subpoena. Next one, we have another personal appearance subpoena for Charles Chuck Gibbons. I think I'm saying that right. Gibbons. Oh, with the ES. Yeah. The personal appearance subpoena for Charles Chuck Gibbons.
Yes.
Okay. So
All of the ones remaining are from our investigation, so they're all just personal.
okay, then let's do this in a bulk manner. I guess I'm going to read off the ones that are remaining. Mr. Residency, let me know if you have any objection to them. If not, we'll do a bulk approval. Chuck Gibbons, Charles Chuck Gibbons, any objection, Mr. Residency?
No.
Rochelle McMullen?
No.
Brian Allen?
No.
Barry Johnson?
Nope.
Cynthia Alexander?
Nope.
Okay, there's no objection. Can I get a motion to approve the issuance of these personal appearance subpoenas?
I just have a question. How much time are we talking about these people testifying?
This is, I mean, if the, the board is certainly within its powers to limit the number of witnesses. I mean, if it's going to be, if it starts to become repetitive, we can, number one, the board can excuse witnesses. That's the first thing. Or if the board wants to, ask the candidate to give, or I'm sorry, not the candidate, the objectors to give more information as to, why all of these witnesses are relevant, because you're right, Member Oswald, this is going to be a marathon hearing.
I will just state for the record, in light of all these witnesses, we will not, speaking to my colleagues, definitively, we will not tolerate cumulative testimony, and they may appear at the hearing, and we may not allow them to testify if it looks like it will be cumulative.
Yes,
All right, then I
yes,
move
loud
to,
room, yes.
grant the subpoena.
Okay.
Subpoenas in plural.
Okay, so the personal subpoenas as read, do I have a second on that? Okay, Chair Raymond?
Yes.
Member Oswald?
Yes.
Member Swanson?
Yes.
Motion carries. Okay, so the personal subpoenas as read will issue.
Then there's one last subpoena. That's for
Oh, yeah,
supplemental
the NFL
request to
Players
the,
Association?
yes, the NFL Players Association, Washington, DC.
Okay. That was
Oh,
this is also, yeah, that was supplemental.
Oh, my.
Oh my God,
All right, so,
that's a lot.
I don't believe there's anything further today as it relates to this case.
Yes, there is.
Oh, there is, I'm sorry, what is this?
The candidate's request for the objectors.
Oh, goodness, I'm sorry. We're going through all the objections. I apologize, I forgot about you.
Yo, they gonna subpoena massive people for a freaking address. This is overload. This is YSL at its greatest. Young Thug case. You dragging all of these people here, and then talking about if it becomes repetitive. And subpoenaing of the wife. Out of one of these people, because they did name like 2 females, I don't know who, so let's not just say it's Linda, and that's allegedly, but somebody gonna find out something. They probably find out not say too much, because they don't want to throw Napoleon under the bridge. We're gonna see who coming there. We got to see this, okay? And then the NFL Association, this shit is gross. I'm sorry, this is gross. Like, this is too much. But I like it. I appreciate being here. You guys as well. Somebody was like, I'm tired of this legal beagle stuff. Well, this is what I love. And this is my angle, guys. So you already know what it is. We're going to focus in on the law, what they saying, do research on it, educate the people. So, one day you could be like Nate Fells. Go up in the court, represent yourself. Shout out to Nate. He definitely on the damn ballot, dog. So now we got Napoleon over here subliminally fighting for his life. I'm fighting for my life. All right. Hit the like button so I can put the Kung Fu Panda hat on for you guys. So I can put my Lori Lightfoot Kung Fu Panda hat on and turn up. We got 30 more minutes of this. All right. I appreciate you guys. Hit the like button. Thank you.
Okay. I got it. Okay, so for the record, the candidates have requested the issuance of subpoenas to, I believe, Mr. Price, Mr. Smith, and
Darlene Harris.
Darlene Harris and Ms. Harris.
And Christopher Clark.
Okay, and the objectors, I know that there was some objections lodged as it related to the issuance of the subpoenas. I know that there's been, earlier in your argument, you were even stating, as it relates, and Ms. Graftucker was also stating, as it relates to the objectors, that how they came up with the objection is not relevant, but they could testify to their personal knowledge. Is that my understanding of what your argument was?
In their evidentiary case, yes.
Okay. And Mr. Lesizinski's obviously arguing that they should be here, that they have filed a verified complaint, verifying that they have personal knowledge, not that they just have information and belief that he wants to probe that personal knowledge. What does the board think?
She said that.
We authorized all 4 subpoenas to Christopher Clark, Keith Price, Darlene Harris, and Michael Smith.
I question the relevance of Christopher Clark. How is he related to this? What's before us?
Well, it's going to be relevant to, for example, you're going to be receiving, or they've already put in front of you, a summary of a bill from the city of Harvey for the Harvey residence of Senator Harris that's listed as vacant. Mr. Clark is the mayor of the city of Harvey. We will be, if the objectors are able to proceed with their case, we will be introducing correspondence from Mr. Clark to Mr. Harris at the Harvey residence. So the issue of if they're going to be introducing documents from the city of Harvey, and an opponent in the case is the mayor of the city of Harvey, and the city of Harvey is producing documents that say the property is vacant, it's relevant to the veracity of those documents.
And what does the objectors?
Thank
you. Object to that?
I don't see the relevance of that in particular, but, you know, we've subpoenaed people to testify because we believe they have personal knowledge, and I'm not going to object on those grounds. You know, if you don't believe the testimony is relevant, then it's not admissible.
We can rule on that at the time later.
And then with regard to our subpoena, we have a typo. It says Harvard versus Harvey on Mr. Clark's subpoena. We
Okay,
just
so
corrected
it's
that.
a
Yeah.
revised subpoena. Yeah, because we don't want them going all the way up to Harvard. That's really one place, one track.
But he said we did not revise the subpoenas, so you're not going to read it, but just, but we will,
Okay, so we have a motion on the floor by Member Swanson to issue the subpoenas as presented. Do we have a second?
I'll second.
Okay.
I would modify the motion as corrected, if they want the typographical.
Yes, and yeah, correcting the scrivener's error. No problem. So the subpoena will, we'll do the roll call. Chair Raymond?
Yes.
Member Swanson?
Yes.
Member Osborne?
Yes.
Okay, the subpoenas to the objectors, Keith Price, Michael Smith, Jerlene Harris, and Chris Clark will issue with the corrections made by Mr. Residency. Both parties, please send me the corrected ones. I will send them over to the chair. We'll get the signatures, and again, just make them.
Wait.
Any signature document.
Y'all just hear that? Is they about to stay subpoenaing Catch a Dog Smith? Let me put him on this. Did they just say that? I'm not rewinding this long thing. Just verify. They about to subpoena this damn fool. They didn't get enough of this meter freaker and his nonsense. And they about just verify, because that's what I thought I heard. Let's finish. We almost done, y'all.
Documents returnable to me.
What?
did we?
Me too.
Ruling on candidates' objection to objectors to request supplemental by going with that one by one, or did they need to issue?
No, I think that going through the one by one addresses the concerns. And, you know, that they requested subpoenas, they filed objections, we took everyone's objections I'm sorry, we took everyone's objections to the subpoenas into consideration.
She tied.
When I say we, I mean them.
She tied.
So, yeah, I think that you're fine with that.
Okay.
The only last matter would be disclosure deadlines for evidence, you know, when this was.
Yes, I normally figure 24 hours because sometimes things come in a little late. So is 24 hours good for the parties, or do you need more time? Do you need 48? And again, this is a deadline before the hearing.
11:30. I have 11:30 in our subpoenas.
That's what I know.
I will be here, so what time is it gonna be here? About 1:30 in the morning?
1:30 in the morning.
Well, I guess, well, part of that, I guess my question is, can we do earlier than 11:30? This is.
The problem with, we can do it earlier, but I have a court hearing at 11. So what I'm going to do is come here, and then if you want to start, and then I can take a brief break. I'm going to notify the judge of what's going on, but you know, there are other people involved.
Would the parties be agreeable to starting at 10 a.m., taking a brief 11? Okay, so we're 11:30 is it? Okay, 11:30 is it? All right. I was just seeing if there was a way to, hold on. Well, you know, I think that, you know, the board, obviously, we got to make sure to give everyone their due process, but the board does have some tools in its tool belt to limit the scope of things and to limit, again, you know, as Member Swanson had said, you know, we're not going to entertain repetitive testimony. And, you know, if the witness is being unresponsive, you know, that's obviously going to be problematic. So the board will, you know, deal with that appropriately. Let's set another date the following week. Assuming.
Here's the problem with that.
Yeah.
I've got vacation plans starting that Sunday.
I'm sorry, I'm about to.
Well, we can always do it. So let me do my thought. Okay. So my thought is that more than likely, I'm very hopeful that we're gonna get through all this on 31st, right? I'll try our best to get through all this on 31st. If we do, we should set a tentative date the following week, because if we get through all of it on the 31st, you guys can vote to make the decision on the 31st. The rest of the board without you could meet the following week and sign and give the decision. Because what we do need to do is we need to remember, not only does the ballot need to be certified, but the parties need to be given their opportunity to file any sort of petitions for judicial review that they may need to file or want to file. So I want to be mindful of that And I also don't want to get, Janelle or our new clerk, Monica Gordon, upset with us for taking too long to hear these cases. So we got to keep these things moving along in a great expedition manner. So my suggestion would be on the 31st. Let's try and do this to completion. You guys hopefully will issue a decision on the 31st. Then I will draft the written decision. We will come back the following week and issue and tender the written decision in open session as required by the election code. I could try to do Tuesday, what? Let's be here what?
Why would it happen 7th?
Hurry up.
Oh.
This is just a lot of logistics about the date. I'm just really trying to listen. So we definitely know the follow-up evidentiary hearing is on 131. And I don't think that's going to, the first person is going to be in front of everybody when she evaluate what comes in from the subpoena. And then on 2/4 is when they're going to issue the written findings. So they're going to decide on the 31st, just like they did with Nate case. He came in, he talked, they basically said he was off the ballot, and then they said 5-10 days or 5 or 6 days later he could pick up the letter, and then from there he had time to appeal. They're trying to move things along because these people need to be on a ballot by a certain time. So they definitely trying to knock Napoleon off. So let's hurry up and fast forward this because there's a little bit more to this.
I'm not available Saturday, the first. I have a decision on it. I'm available the first, and I'm also available by, so you said that was a personal matter. Yeah, let's do the fun. Can we do the 5th? Can we do the 5th? Can we do the 5th? Can we do the 5th?
That works for me.
5th does not work.
Yes.
5th, 6th, and 7th. Okay. Well, yeah. Okay. The Monday and Tuesday work.
No, I'm not gonna. I mean, I've got a brief due.
Oh.
I've got to write a decision with a whole bunch of testimony.
She's stressed out. She's stressed out, yeah.
Me too.
Just
10 minutes. But Tiffany has to get there.
right.
Hold on. Yeah, that's the thing. I have to write it. I think I have to write the decision. I'm pretty superhuman, but I'm not that superhuman.
The chair can write it.
I've never had that happen. Right. Or you can just. No, I'm sorry. You should totally be not on the record right now. I apologize. Let's go off the record. We're talking about scheduling. So yeah, I guess we could do the 4th. Hannah will just come and give the written decision on my behalf, and then I will keep working on it. Response for a reply brief to you. We all just kind of switch spots.
Yes.
Musical chairs.
What time on the 4th?
Hurry up. Y'all saw Henyard in there? Who the hell was Henyard bent over talking to? We got to go back to that little scene. Y'all saw Henyard in that motherfucker? Who she was talking to? Oh, y'all saw Henyard? All right, let me just let this play. Let me let it finish. I got distracted. I start thinking, like, who the fuck is she talking to? Henyard was bent over like this.
Does that work for the parties?
Yes.
Burgundy Boo got that one. But Smith not right there. That wasn't Smith right there.
I just love double booking myself. Got 2 briefs due on the 29th.
She's stressed out now. I look. Get somebody else to do it.
Look, this coming down to the end. Burgundy Blue camera going all over the place. She like, shit, give me some sugar. I'm with you, Bird. I'm back. You feel better? I got this pillow.
Okay, so I can go back on the record because I will. So just for the record, we will return here on December 31st, January 31st, thank you, 2025 at 11:30 a.m. And then we will return again, hopefully for issuance of the decision on February 4th, 2025 at 1:30 p.m. Yeah, that was what I was suggesting. Are the parties good with 24-hour disclosure rule? 24-hour evidentiary and witness list disclosure rule? Are you okay with 24-hour evidentiary disclosure? Evidentiary witness disclosure? Correct. I'm fine with that.
Yeah,
Okay. All right, so
The other cases
we're gonna go through them very quickly. All right, so there's nothing further for this case today. So, Mr. Mullen, you're excused.
I'll have those updates to you in.
Okay, great. I'll make sure to copy Ms. Watney as well.
What next case? Yeah.
All right, so the next case we're gonna call on docket is 25 TOEB Soup 01C. And that is Keith Price and Michael Smith versus Napoleon Harris.
Oh, he got all the pictures. All right, look, we coming down to the wire, and I'm gonna have to do this right now. We got these applehead. I'm about to say it, Dick Buckus.
This is not a test. This is your emergency broadcast.
Yeah, we got a problem. This is who's coming in. Let's watch. Now I done woke up a little bit more. We got Stooge 1 and Stooge 2. I wanted to make a noise with that face, but it didn't come out right. Let's get it. Let's finish off this broadcast. That done woke me up. Look at it. Look at that head. Look at that up head. Let's go. Let's go. Look at this. Look at this shiny, half shiny, losing your hair bald. Shave your hair down every day because you got bald spots. I got jokes.
I do see Mr. Max Allen, you're at the table with them. Are they no longer pro se? Are they now being represented by counsel?
This is gonna be quick.
Does the candidates counsel have any objection?
If he's here to ask for a continuance, and I think yes.
Okay, are you ready to proceed today?
I got something to see.
I therefore have an objection.
I would not recommend any continuances. We are so close to certification. We're past certification. So.
Thank you for clarifying that. I do understand.
Why are we looking at the back of this lady head?
Okay. Okay, does the board want to entertain any sort of continuance or just want to hear argument today?
Remember that?
Okay, there you go. I don't even think we need to take a vote on that.
I remember that with the hearing that KP had with them. He was trying to put the motion into dismiss, and then you had Napoleon lawyer from, remember the last live? That's why I'm like, oh man, they back again. And Napoleon lawyer was like, no, you can't withdraw your shit. It gotta be dismissed. So this what the hell we hearing, the end product of that.
Yeah, limited to 10 minutes per side is what we did in the other case. So the board's gonna impose that limitation on this case. So with that, Mr. Residency, you have the floor.
I will try to do the outline like I did for the first motion. This is the objector's petition that's missing a page.
Oh boy.
Front page, last page, middle page isn't there. And on that middle page are all the key allegations that relate to whatever remains in this objection. First of all, with regard to the residency objection, they say, number one, residency is all on page 1. A short, succinct objection. But these two objectors have filed a petition beforehand. You can't get 2 bites of the apple. You can't sue people twice for the same thing. Oh, that's more malicious mischief, Ms. Raymond. Is there?
Is it ready yet?
No, they have not. There's a series of emails where Michael Smith says, yes, I want to withdraw. Keith Price says no.
So just for the record, the emails where Mr. Smith said he wants to withdraw from everything. He said he wanted to withdraw the caucus objection as well as the residency objection. Mr. Price said that he only wanted to withdraw the residency portion of the objection, that he wanted to remain on the caucus objection.
And there's a dispositive motion pending on the residency, okay? And they already have another matter pending. You can't piecemeal, you can't split your claims in two separate filings when they relate to the same facts here. And the same facts here are the candidacy of my client.
I think the board is definitely inclined to vote based upon the representations of Mr. Price and Mr. Smith, as well as the dual objections that were filed. I think the board is inclined to dismiss the residency.
On this case, I move that the objectors, that on that issue of residency, if a motion to dismiss on the issue of residency is granted.
Second. Okay. Chair Raymond?
Yes.
Member Swanson?
Yes.
Member Oswald?
Yes.
Okay, so the motion to dismiss as it relates to the residency objection?
Thank you.
So now what we have is still two objectors that have a prior case pending against the same party, my client. And that case is still pending. You cannot split the claim. You cannot split the claim so now the caucus claim is all by itself. And let's talk about the caucus claim. There are sections, they cite the township code. They don't cite what section of the township code. With regard to the violations of any rules, while they say there's violations of rules, they don't allege any conduct that states that the rules and what conduct substantiates the violation of the rules. Additionally, they do not challenge the results of the caucus. And that is what's required. They don't name all the other candidates in their petition. For these reasons, this petition is deficient. You can't just simply have a statement, there was a violation of the rules, 1, 2, 4, 5, and 6, or whatever they put in their petition, without citing the actual conduct that purports to be the violation of the rule. For these reasons, this objection is deficient. It requires specificity. Fully state what the objection is, what conduct occurred that violated each rule. That does not occur in this objection. And for those reasons, it should be dismissed with prejudice.
Now y'all understand what he's saying? That's exactly what we talk about when we go over these cases, how a lawyer could lose a case because they didn't file it properly. So basically he's saying the filing on its face is insignificant or insufficient, let's say that, because it just say 1, 2, and 3. This is what they violated, but it didn't put in detail. Now, this is what I'm thinking. Remember they said that one of the pages was missing? Maybe they let somebody look at it and somebody was like, this is not sufficient. You know you're supposed to cite law. It's a little weird because I'm going to keep it real. This Buckets right here is pretty versed in law. He ain't no fool. So it should have been cited. So if you have a lawyer that goes put a petition in or a case for you and they say, hey, I have damages related to this claim. Let's say a tort. But if you're not going to name the law and the subject matter to the law, then the claim is insufficient. And then you do have to have a relief in the end. Does that make sense? I know I'm talking law genre, but that's what we should know. You got to have like 4 elements to filing it. And this guy said, they ain't got it. You didn't file the elements to your claim correctly. Does that make sense? So maybe they noticed that and that's why they try to slip that other page in. I'm just kind of throwing that out there. So that's what he's saying. But my thing, if you think it's insufficient, and they just threw out the first part, where they was contesting the address, they the board said, we're going to accept them withdrawing because that lawyer was like, hell no. And the boy like that, we over this. But in this last part, they say that I guess this guy is not withdrawing that objection, but Smith is withdrawing the objection for about the caucus because Smith like shit. I let me give it to this fool. Fuck it. So this is what's going on in this last section. Does that make sense? If y'all missed it, let's play it.
in the argument, the merits of the objection, which counsel agrees with you. It's not working. Got it. Can you hear me now? Thank you. Yes, Madam Chair, I would love to engage in the merits and the arguments of the merits of this matter, but I don't think we're there yet unless this board grants or denies the motion to dismiss. We're here on, my understanding is they don't want this to go forward because page 2 is missing, and according to their own motion, these were not fully or well planned. But first of all, the objection.
Oh, wait.
To a candidate that the fact that the objector
All right.
not to object to.
Now, I love you, Burgundy Blue, for all your hard work. But damn, y'all know who talking right now? Do y'all know who talking, Miss Solomon? I want to see his face while he talking. Let's listen.
Some candidates and objects to some candidate, that's squarely in the province of the objector. And that's not a ground to dismiss the objector for one candidate or the other. The nomination certificate that produced all these candidates may have come from one caucus, but each candidate stands alone on the specific objection that comes with that objector. Page 3, and now we get into the objector's petition. Even though we don't have a page 2, page 3 of the objector's petition.
Yo, they got Solomon to come up there and talk for them. Solomon up there talking for them. He like, even though page 2 missing, page 3, let's listen. These is the poor defense one. Hold up. Wait. Let's just listen to him start talking again, y'all. I know y'all couldn't hear it too much, but let's play it again.
Candidate or the other. The nomination certificate that produced all these candidates may have come from one caucus, but each candidate stands alone on the specific objection that comes with that objector. Page 3, and now we get into the objector's petition. Even though we don't have a page 2, page 3 of the objector's petition, I believe strongly, has enough in there that clearly and fully stated the nature of the objection. The part 8 and the paragraph below that specifically mentioned Napoleon Harris in his capacity as lead. And he stated and alleges that has violated rules, even though it says above rules 1, 4, 5, and 8 of Caucus Day procedures, in accordance with the Illinois Township Code, which is the 60 ILCS. I believe that's enough. And then it says, while the doctrine rules that specifically targeted one possible candidate, I believe strongly that that alone serves notice upon the object of the candidate of the nature, fully stated, of the objection. I would strongly argue that this board not dismiss this objector's petition and allow this matter to go on to hearing.
Mr. Solomon, let me ask you a couple of questions. Do you agree that the statute does not allow, once the time for filing objections is passed, does not allow amendments?
Absolutely agree.
Then where in this objection do we have before us the substance of the rules to be able to determine whether there was a violation or was not a violation of those rules without amending the objection petition?
The objector's petition clearly states 60 ILCS as the statute that was violated. It's on there. And it's also alleged that rules were violated in 60 ILCS. Now, we don't have the luxury on the second page to do it again. Maybe that would have provided more information, but I'm not here to argue where or what happened to the second page. I'm just here to say that the third page, standing alone and alleging, naming the candidate in his capacity as the comedian, and stating the exact code, 60 ILCS, the Illinois Township Code.
Where in that township code, or 60 ILCS, where in this petition does it point us to what section to look at about us having to throw a pitcher into the water and hope we grab the right one?
I do understand that the specific ones were not stated in the objector's petition. However, it also states that election caucus day procedures, and I believe those are specific in the 60 ILCS, the township code. We can narrow down where caucus day rules are provided in that, and we're not amending. I'm saying that we have enough to go around.
Where on the 2 pages of the objection that we have before us, does it state with any specificity what the chair of the caucus did not, how the chair of the caucus supposedly violated those rules? Where in this objection petition does it state that?
2 places that I can read. Remember, the first one, adopted rules that specifically are.
Where are you reading from?
The only 2nd page that we have now. There are 3 pages, I understand, 2nd page is missing, so the last page, the very last page, where the objector signed at the bottom. And then the paragraph before, section 4, pre-caucus private part, the paragraph before that.
So it's that full paragraph before the number 4 and pre-caucus private part, you're referring to the paragraph just in front of that.
Yes, just prior to that, please.
Does the board want any opinion from me on this?
Yes.
Okay, so my thoughts are, I mean, I've had a lot of experience with caucuses, especially this election cycle. I've had multiple caucus cases that I have, and I've also multiple caucus cases that I've worked on, and also multiple caucuses that I've assisted. And I've also done a lot of election work. I don't think that this meets the requirements of Section 10 at all. There are literally 195 pages of the township code. If you print it out, there to say that, just saying, well, you violated the township code, that's like saying you violated the election code. You know, there's zero specificity. And when we're talking about, you know, the paragraphs that aren't included, you know, the pre-caucus private party, there's nothing that prohibits them from throwing a pre-caucus private party to it. So I personally think it's a great idea, maybe not, but hey, there's nothing in the law that actually prohibits that. That's the first thing. Second thing is, in my opinion, as it relates to any sorts of violations of the rules, they would need to have alleged fraud and mischief and ill intent, ill conduct in order to get past the Lenahan standard, which basically says that we will not delve into the caucus procedures and we will allow the sanctity of the caucus to stand and the will of the voters to stand. I do also note that there was a challenge that was filed in circuit court related to this caucus. That challenge was Supervisor Tiffany Goons versus Napoleon as it relates to the conduct of the caucus. That challenge was dismissed yesterday with prejudice because the judge, I read the decision, the judge basically said, well, you should have gone through the electoral board procedures. So obviously that's why they're going through the electoral board procedures here today. However, I don't think that they put enough in their complaint to withstand a motion to strike and dismiss. It would be my recommendation that the motion be granted.
Petition.
If I may, really
Go ahead.
respond, Madam Chair. We have an unfortunate situation here. Yes, an action was filed in circuit court. However, this electoral board objection was also filed in time. So that covers, and that shows this board that we knew the objectors knew what they were doing and seeking remedy through both channels, the electoral board and the circuit court. Well, the circuit court ruled yesterday that you got to go down to the electoral board first, and then maybe upon judicial review, you may return. And that's what they said in their case, that the circuit court, Judge Moreland cited. But here we have an objector's petition that's missing page 2. Again, I'm not here to belabor that. I don't know what happened. The objectors don't know what happened. But we have a situation where objectors petitions were filed, and it doesn't have page 2. And maybe, and I know that we would rely, we would have been able to use the information we have on the now missing page 2. And maybe this board would have been informed as to the questions that the board is asking. But my argument is given that page 3 certainly enough notice stands alone to allow us to proceed with any evidence of any hearing.
Based upon what I've read in the objector's petition, what I heard in the prior evidentiary hearing on this subject of what was filed, and looking at this, we should grant, my motion is that we grant the motion to dismiss on this objector's petition on the caucus issue.
Mr. Chair, Madam Chair, would you please allow my objector to address the board?
And pardon me, I don't know the names. One has withdrawn, and I don't think we ruled on that.
Mr. Smith, the one in the middle, he sent in a withdrawal. Mr. Price, the one far left of the table, he is still, he's still in the caucus.
And we can allow him to speak with.
Well, now he's represented by counsel, and he's asking your permission, he's asking the board's permission.
Yes.
Thank you.
And your motions?
Thank you.
Thank you. Electoral board. As we all know, page 2 is missing. I never even asked you all, could we try to get it back? Reading page 3, it clearly states that the rules that were broken were caucus day procedures. There's a list of caucus day procedures in the caucus guide that is issued. The caucus has a whole separate guide. Under caucus day procedures, you can easily see number 1, 4, 5, and 8. 8 being over this particular paragraph that I'm speaking on. And of course, 1, 4, and 5 was on the previous page. The violations are clear. The area in which the violations occurred is clearly states caucus day procedures. So that was straight out of the caucus guide that everyone has. So I would like for this page to be amended, of course, or this motion to strike and dismiss not to be granted, because there is enough information on the last page to address all the caucus day violations, with the exception of caucus participation violations.
Dismissed.
On page 2.
Let me just clarify one thing. Everyone does not have that document you referenced, because it was not in the packet of materials that had been submitted to members of the board. So no, everyone does not have that.
And let me just say, I've never dealt with a caucus. I have
I
not.
have.
You have.
It literally helped edit the chapter of the vehicle, so.
You
I
have.
all read on it.
You have, you're not voting on this.
Correct, I'm not, I'm just making a recommendation.
And one of the people voting doesn't know what the issues are. I don't know. And I was curious, I know nothing about how caucus is run, so I don't know what the legal argument is, and it was not put forward in here. So that's the problem. And it's not up to the lawyer to explain to me how a caucus is,
Correct.
function, because that's part of, and it's not that it has to be every exact fact, but you give me nothing.
And if I may, one other thing is, that the caucus guide is a publication that's put out by the Illinois State Board of Elections, similar to the candidate's guide. So it's a guide, it's a how-to. It is not something that you base your objections upon. If the objectors wanted to hone in their objections, there's, it's literally a very quick search of the Illinois Township Code. There is a specific article related to caucuses. They could have at least cited that article. They did not even cite that article. They just cited the entire Township Code, which is 195 pages. I don't think that sufficiently apprises anybody of what the nature of the objection is.
I agree with you. I really don't know what the problem was.
This guy.
Therefore, I renew my motion before this electoral board, that we grant the motion to strike, and this motion to dismiss the objector's petition as it relates to the caucus issue.
Second, and was the objector done speaking, or did we cut him off?
No, I understood that even bringing the caucus issue before this panel, electoral board, that I knew the board didn't actually have the authority to even rule on the violations at the caucus. I already knew that. I knew that this would be shot down because the board doesn't have the authority to rule on the violations of the caucus. That's why I filed it in the first place, so I could take it to court afterwards. But, I mean, of
And I
course,
think the judge in the supervisory hearing has said we do have authority, and I think I remember.
In fact, yes, so there's been plenty of cases in which caucus results have been challenged. I myself was not a party to one, but I represented multiple candidates as it relates to caucus challenges. There is a mechanism to challenge the caucus and to challenge the nominees from the caucus. I mean, obviously, we're here today challenging the nominees. In the other cases, challenging Napoleon Harris and Mr. Baker as it relates to their eligibility. So there are mechanisms to challenge the caucus. There are mechanisms to challenge the results of the caucus, but that's only if you can prove fraud and other things. And really, the Lenahan case and the Hacker v. Haley, and Hacker v. Haley are really the seminal pieces to look at when you're looking at not only how to conduct a caucus, but how to challenge the results of the caucus.
And I think I remember Attorney Solomon at another hearing saying, I wish I had written the objection. I have a feeling you wish that today. But with page 2 missing, we really have nothing in front of us to.
Dismiss.
So my suggestion would be we call the roll now and we move on to our final case. Chair, so just for the boards or for everybody's edification, the board's now going to roll on the motion to strike and dismiss as it relates to trustee O1C. I'm sorry, supervisor O1C. Yes. Okay, so Chair Raymond? Yes. Member Swanson? Member Oswald?
Yes.
Motion carries. That matter is dismissed. So now we're going to move on to the trustee case.
Can Mr. Solomon file his appearance, please?
Yes, Mr. Solomon, can you please send us?
The board has done everything to do that, right?
Yes.
Yeah.
Yes. Do we have to vote on it?
Do you want me to, do you want to do that now, or you want to email it to
Do
you?
you have any?
I have it.
Let's see if we have any blank ones. Yeah. And if we
And
do,
I'll start with the one who's with the
okay.
He doesn't have it.
That's all for record. One moment. So you're gonna take everything.
That's not him. That's not him. It's him.
Okay, so back on the record, we're going to call case number 25, TOEB trustee O1C, and that is Keith Price and Michael Smith versus George Baker. Okay, so I was approached by Mr. Price right before the hearing started. He had stated that he's going to withdraw the challenge to Mr. Baker.
Is
Mr.
Mr.
Smith also?
Petition? Is Mr. Smith also?
Mr. Smith, can you step up to the mic? Are you also withdrawing the objection?
Cynthia, tell me what to do. It looks fine on my end.
Yes.
Tell me what to
Stephen
do.
Lesinski, Ross Seckler, Priscilla Centel on behalf of the county.
And do you have any objection to the withdrawal of the objection?
I have no objection.
Okay, so.
Let me know what to do with my mind.
I move that we accept the withdrawal and dismiss this case.
Go left.
Okay, Chair Raymond?
Yes.
Member Oswald?
Yes.
Member Swanson?
What's your son, Mr. Lesinski? Malicious what?
Mischief.
Yeah, that's what's going on here today.
Is that better? Thank you, guys. It looks different on my end. I don't have my other phone. Thanks for being patient.
Okay, so there's no other matters before the board, but we do have to call for public comment.
A bit more? I'm against the wall. I'm against the wall now. This is the best I could do. Be crazy. New trustees.
All right, y'all. That's the end. That is the end. We'll figure out about Baker. The main thing is that we're gonna have to follow up on 131. Hopefully, Miss Burgundy Blue go live. I want to say thank you and shout out to Burgundy Blue for doing this live, capturing this. Please go check out her live. Get her some views. You know what I'm saying? All of this is all in the name of the Dalton and Thornton residents. I want to say thank you to everyone who rode out with me all day. Thank you, Brilliant Disguise, because I've been a brilliant disguise with you today, and I've been on it. Actually, I'm going to give a shout out to my favorite resident. I want to be honest. I'm like, yo, she's on task. She keeps me on task. There's a few other residents as well, but my favorite resident, she has made today possible, and she didn't even know it. Not only with the, the support she give me, just like I want to say to all our mods, the support you give me. Without you, Honeymoon, you was the first, one of the first that said, yo, I'm riding with Grace. I know she be running her mouth and say what she want to say, but I see her heart. So thank you so much. She's been trying to get up to 200 likes for this video. And because Miss Brilliant Disguise, Mr. Been here all day with us, I am going to be nice and I am going to do the panda dance. So you already know our goal is to get this chick to unass her seat. Okay, so with that goes to say, this is what she's going to be doing after the Lori Lightfoot report is going to be going down just like this. Now bear with me.
Why are you detaining me? You about to lose your job. You about to lose your job. Get this dance. You about to lose your job because you are detaining me for nothing. You about to lose your job. You about to lose your job. Get this dance. You about to lose your job. I'm Martinez. You about to lose your job. Get this dance. You about to lose your job. Get this dance. You about to lose your job because you are detaining me for nothing. You about to lose.
Am I muted? I'm sorry. You already know that Miss Lightfoot is going to be in the building on Monday, and she's going to be going over the Lori Lightfoot report. Okay, so y'all know I did a part 1. Go check that out yesterday. And also, I do want to share one more thing before we get out. I did see something, and I've been wanting to share. It says that she released her report. Y'all saw this? Y'all know I gotta hit the last shall be first. The last people here, y'all seeing this. I was like, what's this? This was when we was live. I was like, what the hell? Okay. Tiffany Henyard investigation, Lightfoot to release findings on Dalton Mayor alleged misuse of funds. Do you know they changed the title to this? Because they said she released it. That's why I was like, what? It's to be released. So that's what we're gonna be doing on Monday. They be updating stuff. Maybe I was sleepy, okay? Maybe I saw that they released it, but this is what's gonna be going on Monday. Let's just play this real quick and we're gonna get out of here on a Hebrew note. I want to say you are amazing. Thank you for being part of the Levi family. Thank you for sharing your time with us pre-Sabbath, and you know how we're gonna go out. Let's watch this real quick.
We're going to find out more about Dalton Mayor Tiffany Henyard and how she spent her. We're going to find out more about Dalton.
Hold on.
And her new officer about Dalton Mayor Tiffany Henyard and how she spent her funds very soon. Former Chicago Mayor Lori Lightfoot and her new officer will be releasing the findings of their investigation into the Dalton mayor on Monday. Lightfoot has spent the past months looking into the mayor's spending spree, including costly trips to Las Vegas last year that were on the taxpayers' dime.
If y'all ain't learned that yet, the mayor, not the trustees that don't do nothing, that only run their mouth. Y'all don't do no work. Y'all forget I am the leader.
Drunk as yeah, スライドするお前の地元にスライドする
Imagine if my small business blew up overnight and I woke up to some sales. Boost this video so people who like my products can find me.
Algorithm. Where you at, bitch? Because I'm tired of posting viral content and getting 2.5 likes. We finna fight, ho.
I'm Cara Wilson. I'm the mother of Alexis Wilson, killed by Daud, Illinois police. At the time that my daughter was killed, Tiffany stood in front of a microphone much like this and said that she stood with the cops and they did do the right thing by killing my 19-year-old child. Not only did she not take those words back, she didn't offer her condolences. She's never said anything. The first thing she did was hire this group of security guards to surround her and PR. So the real reason Tiffany has security is hiding from accountability about what she said about Alexis Wilson when she was killed. Now, if you watch the coverage of this murder, these officers violated her rights, reached in her car, jumped in her car, and put 7 bullets in my child, 2 in her head and 5 down her side. And the next day, you guys tried to spin it like she did something. Watch the video. She did nothing to deserve this. And again, last time they brought up Alexis, she's doing what she does now. Look this way, look that way, every way, but at the person talking. You don't give a damn, and you never did, and you never acted like it. She called out a whole press conference to call my daughter a criminal, and Homewood Flossmoor graduate with no criminal record. But Tiffany, you have one, because we used your mugshot to protest in front of your house. And that's why you hid. That's why you have security. So let's tell the truth, which I know you're incapable of. I wouldn't trust this woman if she stood on a stack of Bibles and had her tongue notarized. Not a damn thing she says comes out her mouth is true. Thank you. Say her name. Alexis.
All right. Okay. All right. Amidst your shattering grief, the mayor of your village, Tiffany Henyard, who herself is a mother to a young daughter, approaches the podium. With a chilling lack of empathy, she callously declares to the public that your daughter deserved her fate, attributing it to her supposed poor behavior. She refuses to even acknowledge your presence as you beg for justice, your voice trembling with raw pain. Is this the kind of leader you want for Dalton? Someone so cold-hearted, so detached, so corrupt that she can turn her back on a grieving mother and a tragedy of unimaginable proportions. You have the power to effect change. You deserve a leader who embodies compassion, integrity, and genuine commitment to justice. Jason House can be that change. Perhaps she can be commemorated with a grand painting, a lasting tribute to the vibrant life she should have led. Another meaningful step could be passing a law in her name that holds law enforcement accountable for using excessive and unjustified force during their encounters. And let's not ignore the true character of Tiffany Henyard, a mayor who has squandered taxpayer money on opulent luxuries like lavish trips, first-class accommodations, high-end meals, and even has taxpayers paying the salary of her boyfriend, Kamal Woods, all while neglecting the very people she was entrusted to serve. Justice for Alexis Wilson, and let's clean house for 2025. The